Good afternoon. Welcome to the Appellate Division First Department. We have some 7 hours of argument time requested this afternoon, so please keep that in mind as I call the calendar. Remember that we have your briefs, we have the record, we're fully familiar with the facts of your case. So please keep that in mind as I call the calendar. People versus Eduardo Ramirez. Submitted. Hidalgo versus WCBS TV. There's no appellant here. Are you sure you want 3 minutes? You want to argue against yourself? You'll submit then? Okay. Rihanna L. Submitted. Sasson versus Dykes Lumber. And that's 5 without rebuttal. You have 4 and 1, are you asking? 4, 1, and 5. Crescent Land versus Illinois Union Insurance.
7 and 3.
Do 6 and 1 and 5. People versus DC Reedy. 3, 1, and 3. B&H Florida versus Florida Notes versus Ashkenazi. We have 3 separate appeals. I'm going to hear them jointly.
Yes, Your Honor. Appellant requests 7, 3, and 2 for the cross appeal.
7 and 3, and then
Well, there's a cross appeal, so I assume it would be 7 and 3 for my appeal, and then a 2-minute response to the cross.
okay, let me see. What are you asking?
On the cross appeal, 2 minutes is fine. On the second appeal, 5 minutes. 1 minute on the third appeal.
Okay. I'll do 6 and 2. You do the cross appeal together. 6 and 2, and I'm sorry, 7 and 1, and 7 and 1. Include the cross appeal in your argument. Okay.
So I have 1 minute for the cross appeal?
Yes, you have set. Yes.
All 3 arguments, I have 5 minutes of argument.
Right. You have. Yeah. Why don't we do the 7 and 1, and you'll work it out because you have, or 1 and 7, if you want to do it that way. Either way. People versus Robert Hernandez.
For the appellant, 7 and 3, please.
Do 5 and 2 and 2. Allied World versus National Union. I'll do 6 and 1 and 7. Christopher versus Piard. Okay, it's a submission, thank you. Mema versus Spa 88 LLC. 5, 2, and 5. Two Girls versus Laria.
Your Honor, for the appellant, 4 and 1, please. And for the respondent, 4.
4, 1, and 4. People versus Carlos Baez Caban. Submitted. Aoki versus Aoki.
Appellant requests 8 and 5, please.
Respondent, Deputy Aoki and Stephen Aoki, request 8, please.
Give you 8 and 2, 8 and 4. Legacy Organization versus Nomalini. Submitted. McInerney versus Archdiocese of New York.
Appellant, 4 and 1.
First case for argument is Sesson versus Dykes Lumber Company.
Good afternoon, Your Honors. May it please the Court, Kevin McCaffrey for the appellant Dykes Lumber. Given the time we have today, I'll get right to it with 2 words I'm sure the Court's expecting. No causation, not just under Nemeth or Dyer or any of the other decisions that were recently issued by this Court, but really under any rational analysis of the case. Because what does the case present? The case presents insufficient, vague facts from 50 years ago and expert reports offered by the respondent that don't even mention Dykes Lumber, really mainly because they can't. And I would say we don't even have to reach the expert
Counsel,
reports.
isn't this a case, though, where their expert actually does refer to specific simulation studies having to do with these specific products and giving actual numbers as to the amount of asbestos being released into their breathing zone? Why isn't that kind of specificity, which is very specific, sufficient to raise an issue of fact as to causation?
Right. If you're referring to Dr. or Mr. Garza's report, I assume? Well,
Dr.
Mr.
Ginsburg's,
Garza's...
I think. Garza's report.
Okay,
yes.
yeah,
Ginsburg's reference to Garza's report.
Right, yeah. Mr. Garza, the industrial hygienist, well, that's just the problem. This is the same canned report that Mr. Garza has offered time and time again in dozens and dozens of cases over the years. It's not case-specific. He does basically offer a whole litany, over 150 pages of prior studies, which could be applicable to this case if he had bothered to refer them to this case, but he doesn't. His report doesn't mention either Mr. Sasson or Dykes Lumber. In fact, it doesn't even have this case on the cover, which would have been a nice addition, I think. And I think that that's why, most recently, Judge McCormick in Nassau Supreme, in terms of ruling on this exact same report, it was, again, the exact same report in that case, his quote was, "The Garza report is a meditation on all types of products that contain asbestos, but does not actually speak to the facts of this case in particular. Unreliable, summary judgment granted." So that was his finding on that. And interestingly enough, in that case, there was also a report by Dr. Ginsburg as well.
Does it have to be, talk about the individual plaintiff, or does it have to establish that these kind of products used with regularity, which it clearly was in this case, and it's clearly this testimony in this case to support it was used regularly, is sufficient breathing in to cause this disease that was caused in this case? Why isn't that sufficient?
Well, it is sufficient, if I understand the question. It is sufficient to offer studies and basically an underlying framework for what the conclusion is. But if you don't actually apply the studies to the specific case, then you haven't met the criteria for Nemeth or Pompani or Dyer or any of the cases that were recently decided by this court. And Parker as well, going back further, you have to at least have a situation whereby the report or the expert, whoever it may be, actually examines this case. Because if that's not what the rule is going to be, then we can have a report from any case, from any prior, I guess, exposure analysis, and not even have it refer to this case, but yet
But
meet
he
the criteria
specifically refers to the company. He specifically refers to Durham Putty when he's talking about it. So he's not just talking about anything. It's that particular product that caused this specific injury. Right. And he's talking about the release of particles and other factors that he mentioned specifically with regard to this product. And then the plaintiff talks about how often he used the product, how he used it to sand, I think, and that these numbers specifically relate to that plaintiff's inhalation and use.
Right. Well, if I may, well, you're correct that that product is mentioned. That's one of the products. But that's not my client does not actually make any products. My client was one of 7 different suppliers, and that's the problem with the underlying facts.
But there is case law that would put a distributor in the loop.
Correct, absolutely, if there were sufficient facts.
So just hold that thought.
Right. If there's sufficient facts, and then those facts are applied to any sort of credible scientific methodology, correct, absolutely.
Okay, so those are the facts I mentioned when you switched to the fact that you have a distributor. Obviously, the distributor sold the product. The product was the Durham Putty. That's what I'm speaking with reference to what Ginsburg speaks about, where he cites, I think, as you mentioned, Garza.
I'm sorry, you're talking about Ginsburg or Garza?
Where Ginsburg, I think, refers to Garza.
Right, exactly. And that's the problem. Dr. Ginsburg's relying on a report that's not case-specific. He actually says, his quote is, "I'm relying on the scientifically sound analysis and exposure assessment," when there wasn't one. So that's the problem with Dr. Ginsburg's report. He's relying on a report that's not even case-specific. So I see my
Thank
time
you.
is up. Thank you, Your Honors.
Good afternoon, Your Honors. Pierre Ratsky from Whites and Luxembourg for the respondent. The Supreme Court's decision below was correct and should be affirmed. The first step of any summary judgment analysis is, of course, determining whether the defendant met its prima facie burden.
What's your response to the argument that it's not case-specific, that Garza's report doesn't refer at all to this particular plaintiff and this plaintiff's particular exposure?
It's twofold, Your Honor. Your Honor was correct that he does refer to specific studies that examine the work activities of this plaintiff and show that ultra-hazardous levels of asbestos are released into breathing zones of workers when performing this kind of activity.
What about specifically where he says that Ginsburg relies on Garza's report, and Garza's report is general, not specific?
Well, my opponent said that it would be okay to have a general report if it's applied to the facts. Dr. Ginsburg is doing that in his report. He applies the studies that Mr. Garza cites to the facts of this case. And again, he also cites specific studies of the Durham product. So this isn't just a generic analysis. This is of the main product he used, and he shows ultra-hazardous levels of asbestos release from the use of those products.
And the facts of this case make reference to the deposition testimony, correct?
Correct, Your Honor.
Where they describe their many years working with this putty doing their woodwork.
Yes, about 13 years doing this work with both joint compound and water putty, and those products are both analyzed in Mr. Garza's report and Dr. Ginsburg's report. He did say that he bought joint compound at least 50 to 100 times from Dykes, so that's some quantification that the experts can go off of. And they, again, first we had to ask whether they met their prima facie burden. In this case,
Let me ask you a question about this. What is the testimony in this record about what these products consisted of, whether they were chrysotile or whether there were other kinds of asbestos fibers? How can we determine on this record what these products consisted of?
I don't think it will be disputed at trial, and trial actually has commenced in this case. We're still in jury selection. But it won't be disputed that these products did not contain purely chrysotile if they contained asbestos at all. The defendants dispute that they did. But they contained tremolite and anthophyllite, which are amphibole asbestos
So even if we
fibers.
accept it as true, the argument that chrysotile doesn't cause this type of disease, it wouldn't answer the question about causation in this case.
Correct. And Dr. Rogley's report in this case, he's their only medical doctor. That's his entire report, is just the chrysotile defense. He just states that chrysotile is incapable of causing mesothelioma,
Well,
and that doesn't really apply to the
sorry,
facts
it
of
was
this case.
peritoneal mesothelioma.
Correct. Correct, Your
That's
Honor.
a somewhat different type of mesothelioma, correct?
Correct, Your Honor. It is the same mechanism of action in that the fibers are inhaled, they get past the defense mechanisms, they reach the target cell, and they translocate to the peritoneum. And again, their expert, Ms. Jacobs, calculated a cumulative exposure dose from all the suppliers of 0.7 fiber years. Dr. Ginsburg cites authoritative epidemiology showing that that is a causative level and known to cause mesothelioma. And in fact, the LaCourte study, which he cites, as well as the Iwatsubo and Rodelsberger studies, show that lower levels than that can cause mesothelioma. So the court below correctly pointed this out and emphasized that it can't possibly be that Dykes has met its prima facie burden of disproving medical causation when its own expert proffers a causative level of cumulative exposure. If there are no further questions, we rest on our papers. Thank you.
Thank you.
Very briefly, Your Honors, if I may, two things. One, Dr. Ginsburg's opinions vis-a-vis industrial hygiene are entirely incompetent. He's not an industrial hygienist. He's a medical physician, so his opinion as to what doses may or may not have occurred is completely erroneous. It's not based on anything other than Mr. Garza's report, and Mr. Garza, once again, doesn't actually provide an exposure analysis. That's uncontroverted. It won't be denied by my good friend, my opponent here, but that's the reality. And secondly, since general causation was brought up, when it does come to this particular disease, peritoneal mesothelioma, it is true, the studies have said time and time again, it is not caused by chrysotile asbestos. In fact, our doctor, specifically cites a study that involved 11,000 workers.
Where did you get, what's the basis for your first part of your hypothesis that these asbestos products only contain chrysotile? Where is that in the record?
Well, I believe that is noted by both our industrial hygienist and our doctor. So that our doctor, I'm sorry, I believe the record is clear on that.
Thank you.
Thank you very much, Your Honors.
Crescent Land versus Illinois Union Insurance.
It please the court, my name is Joshua Mellon, I represent the appellant in this case. The insurance company throughout the last several years has effectively avoided paying COVID-19 cases, relying on pollution and contamination exclusions in their first-party property policies. This is not a first-party property policy. This is a first and third-party pollution liability policy that is a specific grant for pollution conditions. Notwithstanding that, the carrier in this case has now taken the position that COVID and the virus is not a pollution condition, and therefore there should be no coverage under this policy. Specifically, it cites to the fact that the word virus is not included in pollution condition. However, in looking at that definition, the definition is very broad, and it lists, and while it doesn't list virus, it lists a plethora of examples and then uses the word including as opposed to an exclusive list
What
of
about
items.
the fact, though, I'm sorry, go ahead. What about the fact that there's a specific provision having to do with indoor environmental condition which excludes viruses that as a result of communicability through human to human or bodily fluid contact? So we have a specific provision of the policy dealing with viruses, which would certainly trump a more general provision, and that specific provision specifically excludes COVID because that is clearly communicable through human to human or bodily fluid. So based on that, how can you argue that COVID's covered under this policy?
So first of all, I think it's important that we look very carefully at the policy to see exactly what's happened, because basically what the carrier is suggesting is this indoor environmental condition acts as an exclusion within the pollution condition coverage so as to eliminate virus from that coverage. Keep in mind that the indoor environmental condition coverage, number one, does not cross-reference pollution condition. Number two, if we look very carefully at the construction...
There's a separate provision which specifically addresses viruses.
I'm going to get to that. So if we look at the way this policy was constructed, if you look at the record, we find indoor environmental condition initially defined in the policy, and when we find it in the initial coverage grant, you can find that on page 47 of the record. Virus is not mentioned. It only includes fungi and it includes Legionnaire disease. That policy was written in 2000, that coverage was written in 2014. In 2000, their endorsement 28, which is what they rely on, was written 3 years later and becomes an endorsement to which it arguably expands the coverage of indoor environmental pollution.
You're arguing that even though it's clear that COVID's not included under a virus, under indoor environmental condition, because that's more coverage, we should still allow it under the broad pollution?
Well, under indoor environmental condition, virus is included under certain circumstances, which I will get to. What their argument is because it's there, ipso facto, it can't be in pollution conditions. So what they've done is they've created a backdoor exclusion without calling it an exclusion in order to limit the pollution condition definition without any cross-reference whatsoever. When we want to talk about general insurance policy maxims as it relates to what the reasonable expectation of insured is, to believe that that policy provision, that endorsement is going to contract a grant that without it is clear on its face that virus would be included.
But let me see if viruses have been consistently attached to the indoor environmental condition.
The word virus is explicitly stated in the indoor. It's
indoor,
not explicitly
not in
stated
the
in the
pollution.
pollution condition.
But you want you want COVID to be considered in the pollution condition.
Yes, because if you look at the definition includes contaminants, and contaminants is broad enough that we understand that it would include virus, and in fact, policies through courts throughout the country interpreting
Even though you just said that even though the policy has consistently not included viruses in in pollution conditions.
It didn't.
And it's consistently included virus in indoor.
Well, it said the policy condition, the pollution condition says including, it lists a whole series, and then it lists a series of items. So including, as opposed to an exclusive list, does not exclude virus as long as it
But
fits
if you read
within.
the whole thing, I'm sorry, if you read the whole policy together, wouldn't that be inconsistent?
No, because basically remember, this is a motion to dismiss. You have an endorsement that was written that they're relying on 3 years after the initial policy was written that more narrowly defines indoor pollution incident and doesn't include virus. So what they're asking this court to do is to conjecture the underwriting process that went into why they issued endorsement 28.
What I'm having trouble with is understanding why we should read the concept of viruses into contaminant in understanding what pollution condition means when the definition of indoor environmental condition includes a discussion of the word virus. So that's clearly a term that the insurance company viewed as separate from contaminant, or they wouldn't have listed it separately. So I don't understand why we should read it in.
So whenever we get into what the insurance company intended, we have a problem with respect to this being a motion to dismiss. There's no discovery. What the insurance company intended, we don't know what the insurance company intended.
But
The courts have.
I'm sorry, there's no ambiguity in the definition. You're suggesting there is.
I'm not.
Why do we need to go into the intent? I mean, if you look in the definition, followed by contaminant or pollutant, they give a whole host of contaminant that we're all familiar with from a common sense point of view, like soil, silt, smoke, soot, vapors, hazardous substances. And even when they talk about medical or infectious, it's in the context of waste. Virus is not medical waste. Virus is what it is. It's a separate type of
Well, actually, a pathological waste would be is infectious the way virus is infectious. And remember, the word says including. I'm sorry.
The nature of how it affects somebody is one thing. But based on construction of a provision, it's well settled that the examples that are usually given in the definition pretty much give a clue as to how you're defining contaminant and pollutant. And when you think of the common sense, reasonable definitions here, I don't understand how virus, as you suggest, should be shoehorned into the definition of a contaminant.
Again, keep in mind that this is a coverage grant and not an exclusion. We've got examples of exclusions that are interpreted broadly to include anything that sounds like or would be consistent with that definition. And again, they use the word including. They use the word at. This is at a location. That's part of the definition of the coverage that's provided.
Thank you.
That's part of the definition of the coverage that's provided.
Thank you. I'm going to let you ask that question on rebuttal. Okay? Thank you.
Thank you, Your Honor. May it please the court, Anton Metlitsky for Illinois Union. So the main question in this case is whether the spread of COVID-19 counts as a pollution condition under the terms of the plaintiff's pollution coverage policy. Numerous courts around the nation have construed materially identical policies, and each one, without exception, has rejected the very claim plaintiffs make here. The cases that have construed exclusions that my colleague referred to, every single one of them specifically included terms like virus or bacteria, disease-causing agent, and the like, which made clear that those kinds of policies did apply to viruses, unlike this one. This one, the court should follow all the cases that have construed these policies, I think, for three reasons. First, it's a fundamental principle of New York law that the operative terms
Are there any cases that go the other way?
that go, which way is the other?
I'm sorry. You're saying there are many cases that construe this clause as excluding COVID-19. Are there any that go the other way?
No.
Okay.
This, not construing this clause, no.
Can you just, in answering, can you tell me when endorsement 28 was added?
I believe it was 27, it was added after the original policy.
Right, but when?
I think it was 20.
Right, it was before COVID.
It was before COVID, yeah. So three, there are three reasons I think that all these courts that have construed these policies are correct. One is that just the general principle that terms like discharge, dispersal, and the like are read, at least in New York, as terms of art that apply to traditional environmental pollution, which means that even though the word contaminant sort of by itself could include a lot of things, you can't read it to include a lot of things in this policy. You need to read it to include, to apply to traditional environmental contaminants. The second reason is that that conclusion is bolstered by the fact that this is an environmental pollution policy. There's environmental terms strewn all over the policy, which just confirms that this general coverage condition applies to environmental pollution. And then the third really is the one that Your Honors were asking my colleague about, which is endorsement 28. That endorsement is not an exclusion. It's just that you have to read the policy as a whole. And when you read the policy as a whole, this endorsement, which specifically applies to some viruses, not all viruses, so it's limited in that way, plus it only provides coverage for remediation costs, whereas the general pollution conditions provision provides coverage for business interruption losses and remediation costs. So this endorsement is limited in two very specific ways, and if you just read the general pollution conditions policy to just apply to all viruses vel non, you would just be eliminating those very specific conditions in this endorsement, which is something that courts don't do, obviously, when they read a policy as a whole. And as the court has said, they also have this alternative argument that COVID falls under this endorsement, but that's wrong because obviously COVID does pass through human-to-human contact or bodily fluid contact.
Do you see some kind of disconnect from the communicability of COVID versus when it's attached to some kind of fomite and then is on the surface? That's one of the arguments they're making.
I don't think so, because this policy also excludes viruses that arrive in the premises either through human-to-human contact or through contact with bodily fluids, which is what a fomite is, right? Bodily fluids lands on a table or something like that. But in any event, the policy does not use the words exclusively or solely. What that limitation is getting at is environmental-like releases of bacteria and viruses, like a lab leak or a lab accident or a anthrax envelope or something like that. What it's excluding is just normal respiratory viruses, because otherwise you would have coverage for people walking in with a cold or a flu or something like that. And that is obviously not what this is getting at. If the court has any further questions, happy to answer them.
Thank you.
I want to focus on the indoor environmental coverage because I didn't really get a chance to speak about that. The fact of the matter is, as written, to suggest that based on the pleadings, and we gave you various specific paragraphs in which we've identified the fomite transferability, that there would clearly be coverage under that provision, even if the court were to find there was no coverage under the pollution condition. COVID-19 does not merely or exclusively become communicable through human-to-human or bodily fluid. The exception or to the exclusion of that coverage provision says that we're not going to cover it if it's as a result of human-to-human or if it's a result of a bodily fluid. We have, in our pleading, identified scenarios of communicability, picking up on your point, Justice Schulman, that in fact, that communicability is not solely from human to human or bodily fluid. And if you look at the remediation, that's the limited remediation, that would focus specifically on the cleanup of the desks, walls, et cetera, that would have to be infected. And that, in fact, is the way that the Northwell versus Illinois Union case, which they cite, Judge Swain's decision, did not allowed for an amendment of the pleadings to further elucidate the secondary coverage under that case, even when the court concluded that there was no pollution condition found. So while I'm not conceding the first coverage, there would certainly be coverage under the indoor environmental coverage.
Mrs. Leva, did you have a question?
I was wondering how you can reconcile your interpretation with the endorsement 28. But what you've just explained now, how would some company be able to come forward with how it was transmitted, what you just described? If somebody gets COVID, how is it that you would be able to determine that?
Well, it's the remediation, right? It's the remediation that it's limited to. And it is what we needed to do as a result of it being found, detected, on these tables, chairs, et cetera. When one cleans, one's not cleaning because you and I spoke, and as a result of that, you got COVID. I'm not detoxifying you or me. I'm detoxifying the wall or the table, et cetera.
But the vector of that contamination, to borrow your phrase, had to come from droplets. It's well settled. It didn't come like Legionnaire disease where it somehow surfaces through some kind of mold condition in the air conditioning.
But the communicability, I'm sorry, go ahead.
My point is we can recognize that remediation required cleaning the environment, but how did it get that way? Because people went into that area and they weren't wearing masks and they were allowing the COVID to
But that's
be
not
expelled.
necessarily how it was communicable. The pleadings and the studies that we cited on page 30 and 31 of our brief would suggest that a good percentage, and again, we're on a motion to dismiss here, that a good percentage of COVID became communicable through fomite transference, not.
That's also directly addressed in the communicable disease definition, so that it includes both transmission by contact with infected individuals or by contact with contaminated surfaces or objects. So doesn't that include transmission via fomites?
I'm sorry, can you just say it
Well,
again?
it seems to me that the definition of communicable disease
Are you
includes-
referring to endorsement 28 or
yes.
okay, so
And in that includes transmission by fomites, because it specifically says by contact with contaminated surfaces or objects.
right, it just says that that it cannot be communicable through human to human or bodily fluid contact. So ipso facto, if it's
It
communicated.
also then says by contact with contaminated surfaces or objects. So that's your definite, that involves contact with fomites, right?
Correct.
Thank you. Thank you both. People versus DC Reedy.
Good afternoon, Your Honors. Robin Richardson with the Legal Aid Society on behalf of Mr. Reedy. I'm here today to ask this court to reduce Mr. Reedy's sentence in the interest of justice without undermining the seriousness of the offense. In this case, treatment with support with his sobriety would be the most impactful sentence and would benefit the community and while still protecting the community. This offense, like I said, was very serious, but it was an aberration.
Why is it an aberration?
Well, he hadn't had a violent offense in 37 years, nearly 40 years, and in the intervening time, he'd only...
Was he out of prison that entire 37-year period?
In between, he had, I'm not sure how long his, I don't have how long his prison sentence was for the robbery in 1980, but in the intervening years, he had 5 misdemeanors, and from what I can glean from the pre-sentence report, those resulted in conditional discharges, community service, and brief jail terms. So in the 37 years, he wouldn't have been in prison for very long, or in jail for very long.
So in this instance, he punctured someone's spleen, and he held hostage, I think, 4 people total, one including a 6-year-old.
In concert with somebody else. The record is not clear about who committed a stabbing, though somebody was injured.
I think there was also a gun
Yes.
involved.
Yes. So an aberration, this happened after a relapse. He had been sober.
He had held employment?
Yes, he has a long history of stable employment. He also has a history of chronic illness. At this time, he's now 63 years old. And if this court were to grant the relief that we're requesting, he would be released immediately. So just so you know, he's doing quite well. He's very involved in prison ministry, and he's eager to get out to help his aunt who's elderly and not doing very well. His health.
And what are his medical circumstances?
At this point, he's written me several letters. He said that he now also has arthritis and that his back is very bad. He still has his chronic illness, hepatitis.
And how old is he now?
63.
And he's been in for how long?
He's been in for 8 years, Your Honor.
Out of a 12-year sentence, I believe, 12-year?
Yes, Your Honor.
And he has 5 years PRS. If
Yes,
he's
Your Honor.
released.
Good afternoon, and may it please the court, Faith Detrolio for the people. Defendant's sentence is fair and appropriate in this case and should not be disturbed on appeal. As this court has already pointed out, defendant kidnapped 5 people, including a 6-year-old child, at gun and knife point. He bound and separated his victims, and as this court has also already pointed out, one of the victims did have his spleen punctured by being stabbed through the back.
There was another person. Are
Yes.
you aware of who did what in this?
We are not aware, Your Honor. I believe that the other man was never apprehended.
So we don't know whether it was the other man who came up with the idea, whether the other man bound them, whether the other man punctured the spleen, or we really don't know what the each person did here. Is that right?
Correct, Your Honor. We are bound by the record that we have. It had defendant gone to trial, I'm sure we would have found out that information. Instead, he decided to take this significantly beneficial plea deal for less than half of the maximum term that he faced. Just to know all
Was this the first plea that he had been offered?
that I'm not aware of, Your Honor. All of the purported mitigating factors that defendant cites were considered by the sentencing court and
So he had been out of jail for some 37 years, or not out of jail, but had not committed a felony in some 37 years?
I believe that is correct, Your Honor. However, the offenses that he did commit were robberies, and this is an escalation in that same type of behavior.
The robbery is a felony. He only, I understood, committed misdemeanors in that period of time?
Yes, I'm saying an escalation from those type of robberies. This is a robbery, burglary, and kidnapping all together.
So okay. During the 37 years that he didn't commit any felonies, he only committed misdemeanors,
That's
not
correct.
robberies.
That's correct.
So you're talking about when he was a teenager, that offense?
That's correct. Those are his prior
And
felonies.
so the 37 or however many years since then, you're still referring to the case where he was a teenager? That wouldn't have even been able to come in at trial?
Right, Your Honor. The sentencing court was well aware of the time between those robberies and the current one, and obviously found that those mitigating factors, including the time between those robberies and this one, were outweighed by the violence of the
Is there
offense.
any issue that he was a heroin addict still throughout his whole life, had those challenges?
I I believe that is self-reported that he did have those challenges. The sentencing court was aware of those challenges and took them into account.
And that notwithstanding, he held employment?
Yes, that he says that I think he had employment at the time. That did not deter him from the crime and was able to be considered by the sentencing court.
Is there any question that he committed this crime when he was having an episode with, when he had fallen off the wagon, so to speak,
Not
with
that
regard
I'm-
to his addiction?
Not that I'm aware of, Your Honor, but that all those circumstances were taken into consideration by the sentencing court, and the sentencing court found that they were outweighed by the violent nature of the crime. If there are no further questions, we ask that you affirm. Thank you.
Thank you.
Just quickly, I'd like to address that the facts were before the sentencing court, but under the statute, this court can offer this power can be exercised without deference to the lower court. Additionally, even though this was a guilty plea and negotiated under Baugh, which was decided earlier this year, the Court of Appeals has said that the statute, it doesn't matter if you plead guilty or if your conviction is the result of a guilty verdict. The power to reduce a sentence under the interest of justice remains the same. Thank you very much.
Thank you. Thank you both. B&H Florida Notes versus Ashkenazi. Sorry, just give me a minute.
Good afternoon, Your Honors. May it please the court. My name is Christopher Volante, and I'm the attorney for the appellant respondent, W89D5 LLC, who's the current owner of the property at issue. As Your Honors mentioned, there's 3 appeals here for 3 interlocutory orders of the Supreme Court, which we assert should all be reversed. Obviously, given my time, I want to focus specifically on why defendant is entitled to summary judgment here.
I'd like you to focus on FAPA.
That-
I imagine that's what you would like to do?
Yes, Your Honor, that's what I was getting to. So with the recent enactment of the Foreclosure Abuse Prevention Act, FAPA, it's clear that defendant is entitled to summary judgment here on 2 separate grounds, with regard to the statute of limitations, as well as with regard to RPAPL 1301 sub 3, which was amended by FAPA recently, also noting that plaintiff has not contested that FAPA is the binding law that should apply here.
So you're,
Are there any decisions which have addressed the provision of FAPA that we're talking about here about original plaintiff? Are there any courts yet that have issued decisions?
So with regard to the savings provision, 205-A,
Yeah, but
this court,
particularly in terms of it applying to original plaintiff.
I'm sorry?
The term.
Particularly in terms of it applying to an original plaintiff.
So none that I'm aware of that specifically address this issue about substitution into the prior action and whether that would constitute an original plaintiff or not. I would submit that the substitution of the plaintiff into the prior action, for several reasons, is of no moment. First and foremost being this court has long recognized, and we cited cases in our brief, U.S. Bank versus DLJ Mortgage, Kraft versus Deutsche Bank, that even when those are instances where you had a substitution of a plaintiff who is then subsequently found by this court and to not be able to take advantage of the savings provision. The same is true with regard to the ACE decision in the Court of Appeals. There it specifically notes the fact that HSBC, who was the entity, the second entity, who eventually was found not to be able to take advantage of the savings provision, had substituted into the prior action as plaintiff and prosecuted that action all the way up through the Court of Appeals until it was dismissed in the prior action, and then in the second action tried to claim the savings provision and were denied. And that's been reinforced by FAPA. And
so that in this case, it can't seriously be disputed that B&H Florida Notes, as an assignee in this action, was not acting on behalf of the original plaintiff. He was not an agent of the original plaintiff.
No, certainly not. Certainly not. The facts here and the records show there was an alleged sale of the note and mortgage to B&H around 2015, And that's when they substituted into the prior action to assert their newly acquired rights. They weren't acting on behalf of Wells Fargo or anyone else. And also, we would submit on that point that in this case, the notion that B&H should be able to take advantage of a savings provision is particularly unwarranted because the first action was dismissed ultimately after trial for lack of standing. So they substituted into an action on behalf of a plaintiff who never had the right to start the action in the first place.
That had to do with the paper trail, and they didn't have all the documents in terms of the allonges and things, among other issues.
Yes, they were unable to prove, according to the lower court and this court, that the entity that was holding the note at the time allegedly was their subservicer. And just to make a point, I'm sure I don't have to make it to this court, but unlike most foreclosure cases, the standing issue in the prior action doesn't affect the statute of limitations here because the running of the limitations period is not based on an acceleration by a complaint. It's based on maturity. The note matured on September 1st, 2007. So we're way beyond the statute of limitations as far as maturity goes. And so with FAPA, also, as I mentioned, we would humbly say that it makes clear that the substitution is of no moment because it makes clear not only what Your Honor pointed out about pleading and proving that you were acting on behalf of the prior plaintiff. The legislative history notes, first of all, that the original plaintiff, as they define it, is the one on whose behalf the claim was asserted. Well, you assert a claim when it's interposed in a commencement of an action, not later on when you substitute. And also, when you substitute, when there's a new owner of a note and mortgage, they have the choice whether they want to substitute or not.
And you're saying the GPFC was the original owner?
Yes, I believe that is accurate. And also, if I can quickly, also with regard to FAPA and RPAPL 1301, sub 3, that makes clear now if there's pending actions related to the mortgage debt and you don't get permission from the court to start the action, it's a mandatory condition precedent that mandates dismissal regardless of any alleged lack of prejudice. And here we have 4 actions that were going on at the same time, with this being number 4. Well, at the time this was commenced, the prior foreclosure action still had a pending appeal with this court. And there were also 2 money actions on monies owned under the note that were filed in both New York County and Richmond County. Both the plaintiff and the Supreme Court ignore the New York County action, even though that's the most prudent because that one is not only was commenced and was pending when this was started, that one had an answer filed, that one had a pending motion from the plaintiff for summary judgment at the same time that this action was commenced. And again, prejudice itself doesn't even play a part, but even if prejudice did play a part under FAPA, there's clear prejudice there. We're defending 2 actions at the same time on the same mortgage debt. And so there's no real, under FAPA's now amendment of that provision, there is no, as far as we contend, that there's no question that dismissal through FAPA under RPAPL 1301 is mandated because we have asserted that as a defense since the outset of this action, which is the one sort of, if you will, exception to that rule where it's mandatory dismissal is if we don't raise it, but we raised it. And so FAPA alone, under both those provisions, grants us summary judgment, particularly when we take into effect, as we argued in our briefs, that their cross motion that they filed and their opposition to our motion was untimely, on its face, untimely, filed 5 days before the return date. Should have never been considered.
Thank you.
Thank you, Your Honor.
Counsel, you
Good
have
afternoon, sorry.
your response and then your cross appeal. I gave you 7 and 1. Do you want to take the 7 to respond to this?
I would like to take a few more minutes than 1 minute, Your Honor.
That's why I was saying 7 and 1, and you said, well, 1 and 7, but.
I was kind of confused how it would play in this with the 3 appeals, but I'd like at least 3 or 4 minutes to respond to this FAPA argument.
I'll give you that.
Thank you, Your Honor. First, as this court is well aware, that he raised this FAPA argument on appeal. It was never briefed before the lower court. And if it was briefed before the, I'll strike that.
When the lower court decided this case, FAPA hadn't been passed yet, so he
That's
could have raised it then.
That's correct. But to raise the FAPA issue on appeal without first going to the trial court and raised these issues because there was specific reasons. The issue of substitution. That not only did my client make an application on the underlying action to be substituted, there was documentation that there was an assumption agreement. All these facts were not.
How does this change the applicability of the statute of limitation, excuse me, how does that change your client's ineligibility for the extension of time given FAPA's exclusions?
The CPLR 1018 is the substitution statute. My client pursued the action as if he was the original plaintiff. It says it right in the.
Can you discuss the specific language of FAPA, assuming and taking it as true that your client was validly substituted and they were in the prior action, they were litigating the prior action, they didn't ignore the action, assuming that all to be true, how do you get around the very specific language of the new amended CPLR 205A, which seems to say on its face that only the original plaintiff has the right to take advantage of 205A now, and that an assignor, which your client clearly is, does not have the right anymore to take advantage of 205A?
Well, by definition, a substitution does stand in the shoes of the original. I get it.
Right, but that's different than, we have to grapple with the actual language unless it says they're acting on behalf of the original plaintiff. So that's a different analysis for us than substitution.
And I'll say exactly that they actually did proceed on the underlying hearing before Judge Enron, that they prosecuted the action as if they were the original plaintiff.
But the question is if they were the original plaintiff, but whether they were acting on behalf of the original plaintiff. That's what the language of the statute is. And there's no evidence in the record that I could see that they were acting on behalf of the original plaintiff, correct?
Well, if you take the whole commercial transaction at the UCC as a whole, if you take that away, then there's no commercial transaction.
Sorry, there's no what?
There's no commercial transaction. Wells Fargo sold it to my client.
May I just ask you, just to be clear, Grand Pacific Finance Corp. is the original?
No, Wells Fargo is.
Well, what is Wells Fargo seeking? Aren't they seeking the property because of foreclosure, because of the default in payment?
Correct, and that's
and
what.
Didn't that happen? Wasn't it Grand Pacific Finance Company that was the original lender, and it was Ashkenazi who defaulted to Grand Pacific?
That's correct.
So then, how would Wells Fargo be the original
Wells Fargo
owner?
was seeking a foreclosure, a statutory action.
But the foreclosure happened against Grand Pacific. The default happened against Grand Pacific Finance Corp. So they were the original owners. After that, it's been assignment after assignment. Isn't that right? Wasn't it assigned from Grand Pacific?
That's correct. You're absolutely correct.
So then, how do we get to the original owner as Wells Fargo under the statute? That's all I'm saying. Under this new statute that it seems we're bound by, how do we get to Wells Fargo?
Because you're taking one statute and ignoring the whole effect of what the substitution statute is.
The statute speaks, it says a successor in interest or an assignee of the original plaintiff.
Or for the benefit of the assignor, doesn't it?
It says.
I don't have it in front of me.
It says that, quote, a successor in interest or an assignee of the original plaintiff shall not be permitted to commence the new action unless pleading and proving that such assignee is acting on behalf of the original plaintiff. So this is.
But is that not when you stand in the shoes of another party, aren't you acting legally for the original party? That's what substitution is.
It's not. I mean, that's not my understanding of a substitution. It may be that you want to assert the same kind of rights that the original person had, but it's not necessarily clear that. And is there any agreement in this record that if you were to succeed, let's say for the sake of discussion, you were to succeed here, that all that money is going back to Wells Fargo?
Well, they already received the consideration already.
That's my point. So you're not
But there
doing
is
it
an
on behalf
assumption
of Wells
agreement.
Fargo.
There are documents.
Sir, let me finish.
Okay.
You are an assignee. You're not an agent of Wells Fargo. You started this action on behalf of B&H Notes to recover in this foreclosure action. It's for you in this context. So since you're not acting on behalf of Wells Fargo, I need to understand, notwithstanding your rights under 1018 to be substituted, that's a whole separate right to stand where you are. And putting aside whether you have standing or not, the issue is under this statute, are you acting on behalf of the original plaintiff?
I would say the whole commercial setup of just assigning notes, the whole UCC is based upon the portability of different notes. If you take that issue out and people can't assign it with certainty, and you can't substitute and foreclose these notes, you are acting.
Well, it's not saying that you can't. It's just saying if you assign it, it better be the original owner that assigned it, and the assignor had better be acting on behalf of the original
Look what
owner.
you're saying. Then you make it extremely difficult for a commercial transaction to happen. If that's what this court wants to do, then that's
It's not what this court wants to do. There's an action.
I mean, I'm sorry, I didn't mean it that
Foreclosure
way.
Abuse Protection Act.
Mortgages. It's mortgages. It's protecting mortgages. You're
Right.
referring to all commercial sales of notes.
I've allowed you much time over your time right now.
May I go with my cross appeal?
I'll let you do that when you come back, yeah.
Thank you, Your Honor. I want to obviously spend my time talking about the cross appeal, but before that, I do want to note with regard to
You have 1 minute.
the lower court, that the court has to apply the law as it is. The fact that it wasn't raised below is irrelevant. With regard to the cross appeal, the Supreme Court rightly denied their motion for summary judgment. The original affidavit, they rely on the fact that the note was attached to the complaint, but this case law, we cited it in our brief. When you're relying on an allonge, which they are, you have to establish that it's firmly affixed. And there are case law clear, even when you attach to the complaint, you still have to establish that it's firmly affixed. And if you don't do that, then summary judgment is denied. Here, the original affidavit didn't attest to it being firmly affixed, didn't attest to any review of the note to corroborate that it was attached at the time or firmly affixed at the time, and fully hearsay affidavit. There's no foundational testimony from the affiant to lay the foundation for business records. There's no attached records to establish standing. And then looking at what was presented itself, the allonge has hole punches on some pages and not others. It's undated. There's no pagination. In the summary judgment motion, they were separate exhibits, while in the complaint where they were one exhibit, in essence, two separate notes, which this court and others have consistently found to create an issue of fact with standing.
Thank you.
If I may can I make one tiny point, one further point?
Okay?
Okay, so it's just a similar issue with proof of default. Foundational testimony, none provided, no business records, and the affidavit they tried to fix it with in the untimely cross motion, you can't consider because it's re-argument.
Thank you.
Thank you.
You have 1
Regarding
minute.
the cross appeal, it is B&H's contention that they met its burden for summary judgment. Attached to the complaint or exhibits such as the note and the allonge, we provided an affidavit on the second in the re-argument motion because they basically opened the door for this re-argument by making a summary judgment. And in opposition, we put in this affidavit. The court considered it.
You're referring to the Levy affidavit, correct?
Liat Toledano, correct. It's in the second appeal record. She correctly established custodian in possession of the prop. She established that the note and mortgage, the original note and mortgage, was stored in a secured area. She established that as an office practice, they scan the documents. took the staples out, and they after they scanned it, they put it back in the original condition. There was no objection regarding this, the veracity of this affidavit, and we also provided proof of default. That we made our case for summary judgment, and summary judgment should have been had.
And now we're looking at this in
No,
the whole
as a general
perspective of
point, that this
FAPA. I just want to make you're aware of that.
I am aware. But I also like to, as a general point, all these arguments that that my adversary is making, none of them were pled, not one. And all the affirmative defenses, even standing, never once mentions the allonge. All of them are one-line sentences. Statute of limitations is barred because the statute of limitations is barred. I have no idea as imposing that.
You're getting back to the statute of limitations issue arises because
Well,
of
I'm just
FAPA.
talking about a specific.
Excuse me,
Sorry.
arises because of FAPA, which wasn't in effect at the time you were in the lower court. So he couldn't have raised it then.
That's not. He could have. He could have made an application to amend his answer at any time.
Okay, thank you. Thank you both.
Thank you.
People versus Robert Hernandez.
Good afternoon. As the court is well aware, there's a pending motion as to whether this matter is properly before this court. If there are any questions about that motion, I'm happy to take them now. Otherwise, I'll move on to the substance of the brief.
You can move on.
Okay. Turning specifically to Section B of Point 1, Mr. Hernandez's robbery conviction was against the weight of the evidence because the jury convicted him of burglary in the first degree requiring physical injury, and then acquitted him of burglary in the first degree requiring the use of a dangerous instrument. And since the remaining elements of the burglary charges are the same, the jury apparently had an issue with the complainant's credibility as to the dangerous instrument element.
Was this made before the jury was discharged, this repugnancy argument?
This is not a repugnancy claim. This is a weight of the evidence claim.
But doesn't it sound like an inconsistency?
It does sound like.
And if it's inconsistency, as I understand the case law, then it was the responsibility of defense counsel to raise it before the jury is discharged. Otherwise, it's waived, correct?
Right. So the reason this isn't a repugnancy argument or an inconsistency argument is because there is a theoretical possibility for somebody to commit both to commit a robbery and not a burglary, which is how the Court of Appeals in People versus Muhammad instructed courts to evaluate repugnancy claims. So there wasn't a valid repugnancy claim, which is why it wasn't raised below. What I'm saying is that the weight of the evidence as to the robbery in the first degree, that it suggests that that conviction wasn't supported by the weight of the evidence because the jury had acquitted on that element as to the burglary in the first degree. I want to turn now to the second point, which is the missing witness point. IV's testimony here was material. It was favorable.
How was it material? She said that she was the same thing that the victim said, essentially, wasn't it?
Well, I want to make a distinction between materiality and cumulativeness here because the burden on the moving party for a missing witness charge is to only show that it's material, only show that that the witness is knowledgeable of an issue of fact that is material, which the defense, I think, met that burden here because.
But if the judge believes it's cumulative, the judge doesn't have to give the missing witness charge.
Right, and I don't think that it was cumulative here.
And so that's what I asked you to begin with.
So I don't think it's cumulative because there's a lot that IV could have added here. She could have told us about who came up with the story about Con Ed, what the complainant's demeanor was like on the phone when she first called her.
But she said she lied. The victim said she lied about that, about Con Ed and everything else. She said she lied about that.
That's right, but there's.
So the jury was able to hear I said it and I lied.
Right, and I think it's important who came up with that story, and Ivy could have told us more about that. She could have told us again about the complainant's demeanor. She could have told us why it took so long to call the police. She could have told us why, whether Mr.
Well, didn't the
Hernandez...
victim speak to all of that? I mean, weren't all of those issues taken up by what on cross-examination and on what on direct with regard to what the victim testified
Well,
to?
the victim testified to some of those issues. Another thing that Ivy could have testified to is whether Mr. Hernandez had a history with other sex workers that she had worked with.
Not to mention, and other sex workers, well, that may have been, but then there would have been an objection to having something come in with regard to the defendant and other workers. But there's still I don't even think that this witness was in the control of the prosecutor. She had said that she wasn't going to testify. She said if she came in, she would lie. She wasn't someone within their control, was she?
So I want to make the distinction between control and availability.
Was she under their control?
I think she was under their control because the prosecutor had contact with her, and the relationship between Ivy and the complainant is what puts her under the people's control. As to the question...
Wasn't it unclear whether or not she would testify favorably to the people?
I don't think that... Again, the favorability element of a missing witness charge asks the question of what is the relationship between the parties. And in people...
So you're saying that goes to availability, whether she was available. Okay, well, she said she would take the fifth, and...
So I think that
And she wouldn't come in.
So the idea of whether she would take the fifth, that goes to availability. And the trial prosecutor said below that Ivy might take the fifth or might lie, and this court has held multiple times in People v. Horn, People v. Neal, that unsubstantiated claims that a witness might take the fifth are insufficient to establish unavailability. And what the Court of Appeals suggested in People v. Savanon is that they bring the witness before the court outside the presence of the jury to determine whether or not they would take the fifth and to ask that question outright. And that could have been done here because, again, the people had contact with the witness. They could have easily subpoenaed her and brought her in to conduct that examination. If she had said at that point that she intended on taking the fifth, then, yeah, she would have been unavailable. But that has to be a substantiated claim that she's unavailable. And with my remaining time, I want to turn to the third point, which is the sentencing point. Now, I understand, of course, the seriousness of the charges, of the crimes here, but I want to just highlight a few things about Mr. Hernandez's extremely traumatic background. He had an abusive father, a drug-addicted mother who kidnapped him when he was 3 years old, and he had to be ripped out of her arms by ACS. He had a mentally ill grandmother who didn't even speak the same language as him. He was homeless by the age of 13, sleeping in cars, and he had...
Were all of those matters raised before the sentencing court?
They were raised before the sentencing court, yes. And one more thing that I think is really important here is that Mr. Hernandez had documented cognitive issues, as we saw from the two 730 reports. And what all of this points to is diminished culpability, and I think especially the cognitive issues here. So we are asking for a sentence reduction to something lower, maybe something closer to what his co-defendant received, which was 12 years.
Thank you.
Thank you.
May it please the court, Melissa Wax from the Kings County District Attorney's Office. In light of the circumstances that led to this appeal being transferred to this court, my intention is not to make an affirmative presentation of this argument, but instead offer to answer any questions this panel may have.
Why wasn't the individual called? Would she have, would it have been cumulative to have her, where she would have been able to provide some other information about this particular woman, given that she had lied initially?
If Ivy had testified, it would have been cumulative, but we don't even need to reach that because defense did not meet their prima facie burden in this case because Ivy was not under the control of the district attorney's office. Ivy could not be expected to testify favorably. Ivy was the madam, KG was the worker. If Ivy were
Was she charged, by the way?
Not to my knowledge, Your Honor. If Ivy were to testify favorably, that is truthfully, in comportment with KG's testimony, Ivy would have opened herself up to criminal liability. We could not expect her to do this. Defense counsel argues that the two were business partners. KG rented her business apartment from Ivy, and Ivy raised the rates. Ivy took a 30% cut of everything KG earned through her sex work. They were not partners and they were not equals. It was a madam and her worker, and Ivy was not under the control of the DA's office. Even before she said she intended to lie, the DA cannot put on a witness who says that she is going to lie, and Ivy offered options. She'd either lie or she'd plead the fifth.
What about the inconsistency that counsel raises with regard to the verdicts?
This is a master repugnancy claim, as Your Honor questioned my opposing counsel about. It was incumbent upon the defendant to raise this before the jury was discharged. And while when performing a weight of evidence review, this panel can look at acquittals, we know from Abraham that an acquittal is not a preclusive finding of any fact that may have underlain the jury's determination. Rather, the inquiry is whether the robbery in the first degree was sustained by the weight of the evidence, and we know that it was. The jury credited KG's testimony that defendant threatened her with a lighter to remain silent while he raped her. Defendant said that he got these things, gloves, tape, on the way to her apartment because he knew bad things were going to go down. KG was a credible witness. The robbery in the first degree, as well as all other counts, were fully supported by the weight of the evidence, and this panel should not disturb this judgment.
Thank you.
Thank you.
First, I want to address the missing witness point again. I take issue with the people's characterization of the relationship between Ivy and the complainant. The complainant actually describes her as, yes, her madam, but also as a friend in the record. And in addition, I think it's instructive to look at People v.
Didn't she also say that Ivy told her to lie?
I'm sorry.
Wasn't there also an issue about whether Ivy had told her to lie?
Well, there was an issue about whether Ivy came up with the story about Con Ed, which again is, I think, something that Ivy could have sorted out here. And I think it's instructive to look at People v. Savanon, which describes the relationship necessary for favorability. In that case, the proponent of the missing witness charge and the missing witness were at one point friends and business associates, but had had a complete falling out and were not in contact at the time of the trial. And the court in Savanon said that because they had a close relationship at the time, the favorability element was met. And I think it's important to remember here that Ivy was the first call that the complainant made after the incident. And I want to briefly also touch on the weight of the evidence point one more time. People v. Abraham, which the prosecution cited here, was a case about legal sufficiency, not about weight of the evidence review. And it is absolutely within this court's purview to consider acquittals as part of the weight of the evidence review. Thank you.
Thank you both. Allied World versus National Union.
Thank you, Your Honor. Misha Tsitlin for Allied World Insurance. The primary legal issue in dispute in this case is whether Pepsi's insurance contract with the National Union covers only direct subsidiaries, as the Supreme Court held, or covers, in addition, indirect subsidiaries, as is our primary submission. Now,
There's no language in the insurance policy about indirect subsidies, indirect subsidiaries, right?
that's right, Your Honor.
And it's not is that a term of art under New York insurance law?
It is absolutely a term of art. It's a defined term under New York insurance law. Under
Where is it defined?
New York Insurance Law 10740 specifically defines subsidiary as a company controlled directly or indirectly by a parent. This is contrary to, for example, what the Delaware courts have held applies in North
That calls for control directly or indirectly.
Yes.
Right? But although in your brief you say that PepsiCo controls Sabra, when I looked up your citations to the parts of the record that you say showed that, they all seem to be to your briefs or motions, not to anything external. So what real evidence is there that PepsiCo controls Sabra in any way?
So I just want to, first, the legal dispute is whether
No,
it
I'd like you to address my
Right,
question.
right. So if Your Honor agree with me that it covers indirect subsidiaries.
I didn't agree with you about anything. I'm asking you a question.
And yes, so the citations in our opening brief were all to the record. On our reply brief, we
Right,
just,
but
yes.
my point is that it seemed to me your citations to the record to support your claim that PepsiCo controls Sabra were all citations to your own briefs or affidavits or motions, not to anything external.
That's not correct. In our opening brief, Your Honor, we cited, for example, the claim adjuster's report, our claim adjuster, that said that PepsiCo, as senior vice president, chaired the insurance meeting when Sabra's insurers came in through our claims administrator, who came in on December 6th to talk about how is this contamination going to be addressed as an insurance matter.
You're saying that the claims adjuster established that PepsiCo has control over Sabra?
The claims adjuster reported, and this was that when they came in to have the meeting with Sabra about Sabra's insurance policies, who was there? It was a Pepsi vice president. Pepsi's vice president was chairing the meeting. Why would Pepsi's vice president be chairing the meeting for Sabra unless PepsiCo was controlling Sabra? So that's the evidence we have on the issue
That's
of...
the only evidence you have of control, was that there was a person from Pepsi present at a meeting?
No, they're not present at the meeting. She was the one running the meeting. There was no one from Sabra at the meeting. This was our interaction with Pepsi. We came in, we came to Sabra, and who's running the meeting? Not a Sabra individual, a Pepsi vice president. And we have multiple other evidence in the claim in their own claim notes that say Pepsi was running this whole thing. If Sabra is an entity that's not being controlled by Pepsi, why is Pepsi running the only interaction that we have with
Let's focus on
them?
the exact language of the policy.
Yes.
Because you're talking about indirect, direct, but the first step is the policy ambiguous? Do we need to look at any extrinsic evidence? And the policy refers to a subsidiary or a joint venture. And I assume you agree that there's no way that Sabra can be a joint venture of PepsiCo because it's a joint venture of Frito-Lay. So if Sabra is not a subsidiary of Frito-Lay, which it clearly is not because it's a joint venture, how can it be a subsidiary of PepsiCo?
The way it can be a subsidiary of PepsiCo is under the definition under New York insurance law, which the contractual parties agreed to, that if PepsiCo has indirect control over Sabra, then it is a subsidiary of PepsiCo, even if it is also a joint venture of Frito-Lay, which is just a division of PepsiCo. And so the question of control...
And is that in the policy, that indirect language? I know it's in the new section, but is it in the policy that existed at the time?
It is not, but the word subsidiary, as in subsidiary, is a term of art defined under New York insurance law. I mean, I would urge your honors to look at insurance, it's insurance law 10740. It says direct or indirect. This is not a term I'm making up, indirect. This is literally from the very terms of New York insurance law. Now, it's their primary authority that they rely against us is a case from Delaware applying some other state's insurance law, and that Delaware case did hold that under that other state's insurance law, when the word subsidiary is used, that means only direct subsidiary. In New York, however, there is a definition in New York insurance law that says direct or indirect. And Pepsi and National Union are very sophisticated parties. If they wanted to contract around that and they wanted the Delaware definition of insurance law, they can easily do that. And in fact, in December, after this contamination occurred, they modified the endorsement and they said now we need to have, it has to be a company that has consolidated financials with Pepsi. And that's a different definition. But the one that was applicable here is subsidiary. And New York insurance law, unambiguously, I mean, it's plain as day, it says directly or indirectly.
So what is your evidence of the control, other than being at the meeting? What is your, because it's clearly Strauss has some control because it's a joint venture between Strauss and Frito-Lay. What's your evidence that PepsiCo controls Sabra?
I mean, all of our evidence in this case relates to how this particular claim was adjudicated. And I will say that they have absolutely no evidence on the other side. We have a summary judgment issue here. They were granted summary judgment. We had a summary judgment motion. If your honors think that the issue of control is ambiguous, then you got to send it back for a trial. They can't win on summary judgment based on no evidence from them. If your honor thinks our evidence isn't that strong or it's focused on one particular area, then it's got to go back for a decision on the merits. This is why the Supreme Court decided it's clear only on the directness issue.
But you have the burden on that issue, and I'm having trouble understanding whether you're claiming there was any evidence of control other than a couple of meetings with the insurance company at which somebody from PepsiCo was there and no one from Sabra was. Is that everything that you're basing the evidence of the finding of control on?
That is our evidence. Now, it wasn't just, again, it wasn't just the person was there. She was the one running the meeting.
I
Why
understand
is she running the meeting if they're not controlling? And I would say that they don't have any evidence on the other side whatsoever.
Thank you.
Good afternoon. May it please the court, I'm Alan Lyons, representing National Union.
Could you address the question of whether or not PepsiCo exerted any control over Sabra and whether or not the meeting with the insurance company at which someone from PepsiCo was present and no one from Sabra was, is definitive as to control?
There's absolutely no evidence in the record that PepsiCo controlled Sabra. Allied World, as you mentioned, is relying on isolated references to someone from PepsiCo chairing a meeting, running point. It points to PepsiCo lending assistance, lending resources. But that's not evidence of a parent controlling a subsidiary. And this is similar to the case that we cited of Jose v. Stoller and Westbury, where the court analyzed the term subsidiary that was undefined in a release agreement. And the court declined to adopt a broader definition of subsidiary that would include one entity making decisions for another entity. And that's precisely what Allied World is claiming here. And
Counsel, could I ask you a question? The definition says, in the insurance agreement, says subsidiary and joint venture. But it doesn't describe the nature, whether direct or indirect. Can there be a situation where, in this case, Frito-Lay as a 100% subsidiary of PepsiCo, Frito-Lay as a 50% joint venture with Strauss, which would give PepsiCo a 50% ownership because it owns Frito-Lay 100%, could that make PepsiCo an indirect joint venture for purposes of coverage?
No, Your Honor. And I think that we're guided by the language of the definition, which states that the named insured includes PepsiCo and subsidiaries and joint ventures in which PepsiCo has 50% or greater ownership. And the plain meaning is that in order to be a named insured, the entity has to be 50% owned at least by one entity, PepsiCo. And Sabra is not a subsidiary of PepsiCo. It's not a joint venture of PepsiCo. It's not even a subsidiary of PepsiCo. It's a joint venture of a subsidiary, which is beyond the plain meaning of the definition. And we're not asking this court to add any words to the definition. We're just asking this court to apply the plain meaning. And the plain meaning is not that it covers entities in which subsidiaries of PepsiCo have at least a 50% ownership interest. And that's what Allied World wants it to say, but it doesn't say that. And it's Allied World that is essentially asking this court to change the language of the definition to what it wants it to state. And we've just heard that central to their appeal is this notion that in New York, there's a default rule that where a word is not defined in a policy, but it happens to be defined by the New York insurance law, that statutory definition applies by default. Well, that's just not the case. New York does not have that default rule. And Allied World has not cited to any case that says that there's a default rule. The only case that they've cited that touches on the issue is In Re Countrywide, which is a completely different situation. That case didn't apply a New York insurance law definition to an undefined term in the policy. It didn't apply any definition to an undefined term in the policy. In that case, there was a whole sentence that mirrored language in the insurance law about when and how to give notice to the police about a hit-and-run accident. And the court said that because the whole sentence mirrors the statutory language, then that sentence is subject to the same case law that interprets the statute. It's a very different situation. And looking at the course of performance arguments that Allied World has raised, we only get to consider those if the court first finds the language is ambiguous. And this court...
The term subsidiary, is it ambiguous whether subsidiary includes indirect subsidiaries or just direct subsidiaries? Is that an ambiguity in the policy?
That's not an ambiguity, Your Honor. And I know my opposing counsel has criticized our reliance on the Liggett Group case in Delaware. But yes, it doesn't apply New York law. Yes, it's outside of New York, and I'm certainly not suggesting it's precedential on this court. But that's the only case which interpreted the undefined term subsidiary in the very context that we're looking at now, a named insured definition. And in that case, the court found it unambiguous, holding that it applies solely to direct subsidiaries. And the court didn't have to add the word direct in order to reach its decision. It applied the plain meaning, which is all we're asking this court to apply.
You're arguing the plain meaning of subsidiary is a direct subsidiary, and to find otherwise would not be the plain meaning.
Correct. And no definition cited by Allied World actually states that it includes an indirect subsidiary. And if I can just close by emphasizing that this court, in this very same case, has already held that the policy language is not ambiguous. Last year, this court ruled that Allied World was not entitled to depose National Union's underwriters on the very issue about whether Sabra isn't insured. And in doing so, held this policy language is unambiguous. And that's the law of the case. Allied World didn't appeal that decision, didn't seek to re-argue it. That is the law of this case, which means that any course of performance arguments are not admissible. And I just want to note that Allied World stands alone in arguing that Sabra isn't insured. ACE is not here, Liberty Mutual is not here. They both paid millions of dollars under their policies, like Allied World, in indemnifying Sabra for its losses. And they're not arguing that Sabra is a named insured. And if I can just close by...
Sabra's not arguing it.
Sabra's not arguing it, correct. Sabra hasn't made that argument. If I can just touch very briefly, I know my time is up, just on the priority of coverage issue.
I'll give you just 1 minute.
But 1 minute. Thank you, Your Honor. If this court were to hold that Sabra isn't insured, which obviously my argument is that it's not, the National Union policy would still be excess over Allied World's policy. If you look at the other insurance provision in the National Union policy, it says that it is excess over any non-program policies, which includes the Allied World policy. And the Allied World other insurance provision doesn't state that it is excess over other excess policies. They're relying on a phrase, by whatever name called, but they haven't cited to any case law that interprets what that actually means. And the plain reading of that language refers to the type of loss or cost that are covered under the policy, not the type of policy.
Thank you.
So, thank you, Your Honor.
Three very brief points, if I may. First, we agree that this is that the term subsidiary is unambiguous. It's unambiguously defined under New York insurance law to include indirect. That's the only basis on which the Supreme Court decided below. The Supreme Court was just wrong as a matter of law.
Counsel says there's no default rule that allows in this circumstance where the provision is clear to default to the New York State insurance law and the definition of indirect.
That is plainly wrong. That's the whole point of the New York insurance law, providing definitions so that parties can rely on those definitions as a default to draft their contracts. What would be the point of having
Even when you have your own definition section.
Right, in which there was no definition section
You
here.
have a policy that's for every state in the United States, which many policies are not state-specific. You don't go to the definitions in each state then to determine what the meaning of that policy is. It has to be contained in the four corners of the policy.
No, Your Honor, you look at the choice of law provision and the provision, and here the choice of law provision is New York. And so by choosing New York, they chose 10740, which includes indirect subsidiaries. And this is a plain legal error that the Supreme Court made. That was the only basis on which decided. And the import of the factual issues of control, that's something the Supreme Court did not decide. Obviously, it didn't have enough time to really get into kind of a back and forth on that here. But I think if Your Honors agree with me that the Supreme Court just messed up the definition of subsidiary in New York law, I think the right decision is to reverse on that basis, the only basis the Supreme Court decided on, and remand for a decision and hopefully a trial on the issue of control, which is what New York insurance law defines the question of indirect subsidiary based on.
So are you saying that there's some case that says that a joint venture in which one of the joint venturers is a subsidiary of another company is therefore a subsidiary of the parent company? Is there anything that says that?
It's not a therefore. The term subsidiary and joint venture are in the contract here. They each have their own meaning. They can overlap in certain circumstances. We haven't had any.
We don't have a subsidiary of a subsidiary. We have a joint venture of a subsidiary.
Yeah, and the question under New York insurance law is whether there is control. That's the only question under New York insurance law. Again, they chose New York insurance law. They could have chosen Delaware or North Carolina or something. By choosing New York insurance law, they bought the definition that subsidiary includes both direct and indirect. And there's just no way to get around the new insurance law definition.
New York law, it doesn't mean they chose New York insurance law. That's assuming the default argument.
Well, that's, I mean,
Saying you choose New York law means you're choosing New York law about how to interpret policies. It doesn't, by definition, mean you've adopted insurance law.
I think it would be an earthquake in New York insurance law if this court were to hold over the city in New York that the definitions in New York insurance law don't apply to New York insurance contracts.
I don't think any of our decisions have ever created an earthquake.
No, I mean,
it'd be amazing if we had that kind
I don't mean to be hyperbolic, but there's a lot of insurance contracts written in New York. If insurers can't rely on the definitions in New York insurance law, that would be, I mean, we got the 10th argued case today. This would be certainly the biggest case that we argued today.
Thank you very much. Thank you both. Christopher versus, Mema versus Spa 88.
May it please the court. David Rutherford for defendant appellant Spa 88. This case involves an unforeseeable event which involved one patron who alleges that she was sexually assaulted by another patron.
Was there any history of criminal activity at the spa?
Absolutely none. The only thing that had ever happened in the spa in the 16 years that the manager was there was that someone misplaced a cell phone. There had never been any assaults, any criminal activity other than a lost cell phone. So there was nothing with which anyone would have deemed this incident foreseeable in any respect. I think that the lower court got hung up on this issue of whether there was two fights. There was only two witnesses in the case. The plaintiff testified that she was sexually assaulted when she asked another patron to give her a massage and he touched her inappropriately. She reported it.
Well, she at that point, her deposition could be read that she believed that the person who you described as a patron was an employee.
Well, she assumed that, but clearly
She didn't ask anyone.
yeah, and employees wear blue shirts with the logo in the front, and on the back it says staff, unmistakable. This person was wearing a black shirt. Add to that the fact that the spa only employed female masseuses. So she went into
Were there
this.
signs up somewhere that says we only employ female masseuses? I mean, how would anybody know that? Because apparently there were people who were on that level, or occasionally people on that level, who would give massages. You could walk up to them and ask, or is that not correct? I know they said that you had to book at the desk, which is upstairs, but presumably there are people who are around, because they said there's a table that's open there where, I think my colleague just said, where one another could give massages. Did you not allude to that?
So just let me clear that up. There's 3 massage rooms, and if you want to book a massage, then typically you will make an appointment, have a massage in one of those massage rooms. There was testimony from the
And
plaintiff.
you book an appointment upstairs?
Upstairs.
Not there at the time?
Now, the plaintiff gave testimony that sometimes masseuses employed by the place would come and ask, do you want a massage? And then they'd have a massage. Well,
So then, to that point, how would someone know? I mean, you would have to have been there repeatedly to know that only women give massages and that these people are in a particular color uniform?
Well,
because this individual was standing giving someone else a massage, which was what made this woman believe, she says, that she could too ask for a massage right there. What was there?
Yeah, so there's 2 points here. First of all, if you take the plaintiff's testimony at its face that sometimes an employee would walk up and say, do you want a massage? Since there were only female masseuses, the only person who could actually ask that question would be a female masseuse.
That's my point. Was there a sign somewhere that says only females give these massages? Is there anything like that here?
No, there's no sign like that at all. But my point is just either you make an appointment or you get asked by one of the masseuses if you want a massage. So my point is, if they only employ female masseuses, the only person who could ask that question would be a female, not a male.
I guess what I'm saying is, if you have such an open business and you're running it in such a casual way that anybody could give massages to anybody else at any time because there's this massage table right in the middle of the place, doesn't that then encourage your guests, to then just make the assumption that someone giving the massage is someone who's there to give a massage, unless there's a sign up that says massages are only given by women, and our employees wear blue uniforms. Otherwise, you're encouraging anybody to just hop on the table because fair to assume the person standing at the massage table is the masseuse.
But that's not actually what the testimony is. The testimony is that there was a table in the steam room, and that table was usually used for scrubs. However, if you had, and the manager gave this in the record, his example.
I understand that that's what's in the record. I'm
or-
asking you, where is that? Was that information up somewhere?
There's no sign that would say that, okay?
So there would be no way that a person would know that. If they didn't stop at the desk and ask that, they just came down, they wouldn't have any idea of that.
Right, but you wouldn't just assume that someone in a black shirt was working for the spa. And even if you did.
You would assume that people just could give one another massages on that table? That said that somewhere?
He gave the example of a wife or a girlfriend, or you could.
I understand all of those examples came from the owner of the spa, but there's nothing, he doesn't cite to any kind of a sign or anything else anywhere that guides people as to what the rules are there.
But
It's like a free-for-all, just go downstairs,
it's not
whatever
a fr-
happened, happened.
Respectfully, it's not a free-for-all.
Okay,
But
so
if-
where's the instruction is all I'm asking. Is there
Even-
anything, any sign or anything?
Well, even taking that example, so someone gets on the table and asks for a massage, that does not make a sexual assault foreseeable, particularly when there had never been a sexual assault. The spa's in business for 20 years, and if you want to use your example where people would just get on the table and get massages, there's no history. There's nothing in 20 years that would make this foreseeable that something like that would happen.
Thank you.
Good afternoon, Your Honors. Jason Steinberg, representing the plaintiff respondent. This issue of the freedom of movement.
Excuse me, could you address foreseeability? Why was this incident foreseeable and something that the defendant should have been required to address by security measures?
Sure. First of all, let me start by saying that you don't have to ever foresee the precise manner in which an accident is going to occur or an incident is going to occur. That's number one. Number two, in the context of this case, let's talk about what's going on here. You have a massage parlor. You have men and women that could go freely in and out of rooms, get half naked
Has
with
there
each
ever
other.
been,
What?
has there ever been any accusation here before about an incident where somebody touched someone inappropriately on the massage table?
There's no proof of that in this record, but I don't want to conflate two bodies of law here. We're dealing with two different bodies of law. The defendant here is conflating two areas of the law. Number one, there's an area of law with respect to negligent security. For example, a landlord has a building where there's a history of crime in the building, and then there's a claim that somebody broke in and committed a crime, and the theory is, well, you should have had more security measures because in the past there was a history of conduct. Second body of law, which he's conflating, that's the opportunity to control the conduct of third persons on your property that are engaging in questionable behavior at the time.
Is your argument about foreseeability dependent on the connection between that this particular person was fighting before and was not removed? If we took that out of the equation and this person had not had a fight before, does your argument fall? I mean, is that an essential part of your argument? That because this person was fighting before, it was foreseeable that he would then commit a sexual assault against this woman and give a fake massage where he assaulted her.
I don't want to limit that to be, it's not that cut and dry, okay? Yes, the fight is a factor, but you have a fight.
But if there had been no fight, the guy just happened to be a customer there, and he pretended to give a massage as a masseuse at the premises, and then he assaulted her. Would you still argue that that was foreseeable?
No, that's a different situation.
So that's what I'm asking you. Is your argument dependent on the fact that he was engaging in this other behavior earlier?
Yes, it's because of the
So if that is the connection you're making, what is the connection? Is it foreseeable? Are you arguing that's foreseeable because someone gets involved in a fight with another customer that involves physical altercation? It's foreseeable that that same customer might, if not evicted from the premises, might later then pretend to be a masseuse and sexually assault a customer, that's foreseeable?
Yes, it's foreseeable because you're not only talking about a fight, we're talking about a gang up of a group of individuals on one person. It was a fight like that. They were intoxicated, they were drunk.
But it was it was a group of men who assaulted a man.
Correct, but they were also drunk.
Okay.
They were
Well, we don't know that they're drunk. I think the only witness testified that they're tipsy, but there was alcohol. We'll give you, there's that. There was alcohol.
Sure.
But it's the one man who comes back and then does this assault, commits this assault. Is that right?
He doesn't come back. He was allowed to stay on the property.
Yes, he stays on the property and commits the assault. So what is foreseeable that if people are engaged in a fight, that one of those people is going to remain and commit a sexual assault?
It doesn't have to be the exact same crime. There's no case that says that. It does not have to be the exact same crime in the context of a situation where you have the opportunity to control the conduct of a person. Again, I agree that there was no sexual assault in the past. I agree with that. We're not.
So you're saying the fact that there was an altercation, any other offense at all should have been foreseeable?
I'm not saying that because a sexual assault and a physical assault are close enoughly related, together with the fact that you have alcohol involved and you're in a spa where women get half naked, there's no control. He admitted, the general manager admitted, there's nothing on the premises that will protect women. That's number one. So when you think you have an assault going on where there's a 6-on-1
Well, then that's a
gang,
separate issue, because there could be, maybe there isn't anything that would, protect women, but there's no evidence that there's been any assault ever. There's nothing that says if you have, a bar, you're selling alcohol, there are men and women, you have to have somebody there to protect women because somebody's going to sexually assault them. I mean,
well, this is a fact-specific totality of circumstances kind of situation. I'm asking the court to look at the facts of the case. You have
the facts of this case specifically.
Correct.
Is that there were people who were tipsy. That's as much as we have on the record. And
I was going to say that's not the only factor. It's not just being tipsy.
okay,
You have a
I
crowd
wasn't
of men.
finished. There are people who were tipsy, who were engaged in an altercation, and one of those people remained on the premises and then committed a sexual assault.
Correct. They all remained on the premises, allowed without any monitoring, no concerns whatsoever, allowed to freely roam.
Okay, I think I said it the way I took out all the other issues, but I narrowed it down. Is that right? People who were tipsy had an altercation, and one of those people remained and committed a sexual assault. That's basically what it is you're saying is the reason for the foreseeability. Is that right? Because there was an altercation, it should be foreseeable that anything after that, any other offense, any other crime that happened after that,
I'm not necessarily saying that because in the context of a massage parlor, in this particular situation, women are clearly getting undressed in this kind of facility. They're allowed to freely roam with no protection whatsoever. You have a group of tipsy, okay, we want to say tipsy.
No, I'm not saying tipsy. That's
saying
what I
that-
read in the record.
That's what he said. He said tipsy, but
That's the only person who said anything about the level of inebriation.
But that's the general manager who observed
Okay,
this.
so then I'm not saying tipsy. That's in the record. So why don't you use, since we're limited to the record, what's in the
The general
record?
manager said tipsy, and there was beer drinking involved. That's what he said, both of those things, okay? And he said he observed this. There was a melee. There was a fight. He told one of them to get outside, cool off. Once that happened, it is incumbent upon him, in this particular situation, because of the situation we're dealing with, a massage parlor, like I keep saying, and I don't want to sound like a broken record, but the lack of security.
It's a massage parlor. I thought it was a spa.
It's a spa, massage parlor. They have pools. They have cold pools. They have scrub. I mean, there's all these things. If I'm not mistaken, I think it's actually a bathhouse. Okay, but it's all that freedom with no security whatsoever. At this point, when you have that kind of tipsy behavior with a group of men getting in each other's throats, one of them has to be taken outside. The case law, Matz versus Nettles, Rivera versus, I forgot the defendant's name in the case, 2 cases in the first department that said, in a situation like this, where you have the opportunity to control the conduct of third persons, where their conduct renders a foreseeable act or an act foreseeable, and you have the opportunity to control that, you must do so. And we're saying, as the plaintiff in this particular case was sexually assaulted, in the case in an area where there's no protection whatsoever, he should have done something like call the police. That's an issue of fact for a jury to decide.
I have a question. Is it significant in any way in your analysis that the plaintiff testified at her deposition that she'd been there possibly more than 20 times, certainly more than 10, and so that she'd actually been at this facility many times?
She's been there before, yes. She's been
Does
there.
that
Yeah.
have any role in your analysis?
No, it doesn't, because that's more to the other body of law. And when you're talking about negligence of security, if she had testified, in the past, men were down there, and I've seen some things I wasn't too thrilled with. Now the argument becomes, well, if they know about that, there should be more security measures. We're not dealing with that situation here. We're dealing with an opportunity to control conduct that's happening in front of your eyes. That's the difference in the two bodies of case law.
So even though there's an altercation, everybody apologizes who's a part of that altercation, people calm down, and then they go back into the area. A barkeeper can't, or anyone else who has that control, can't make that determination that People apologized, everybody calmed down, they went back in. Where is the level of awareness or, I'm sorry, that this is going to happen again? Where's the foreseeability after that, that this can happen again, and so
I think
they
that's
need
an
to
issue of
present it?
fact for a jury. I think a jury should decide, and you make, and you feel free to make those arguments at trial. He can do that and say.
Thank you.
Yeah.
Let me just address the facts that the record has on the fight. The fight was really a pushing match between a Russian guy, a single Russian guy, and 5 guys from Uzbekistan. The testimony is that the Russian guy started the fight. As soon as the general manager found out about it, he went downstairs, he separated them, he brought the guy who started the fight, the aggressor, the Russian guy, up into his office, let him cool down for half an hour, and then he left the facility. So the guy who was the aggressor in the fight had left. The 5 Uzbekistan guys, a couple of their representatives came up to the office, apologized, and said there's going to be no more problems. And in fact, there's nothing in the record to indicate there was another problem with this group. The testimony is they went to the restaurant and they basically remained there. Now, one guy, if you believe what the plaintiff says, came into the steam room and committed this sexual assault. There's nothing foreseeable by this dispute between these 5 guys that would make the sexual assault foreseeable. It'd be one thing if this was a rowdy bunch that was going around accosting women or drunken and running into things or destroying property. This was a dispute between one guy and 5 other guys from other countries. Counsel for the other side keeps referring to this as a massage parlor. It's a spa. It's a day spa. It's located on Fulton Street here in Manhattan. This is not a massage parlor where women are taken advantage of or anything like that. As Your Honor pointed out, this plaintiff had been there probably 20 times, certainly more than 10 times, never without an incident. And I'll just end with where we started, which was there had never been anything on these premises before, ever. There was no reason for anyone to have any problem. So some guys get in a dispute, it's settled. That doesn't make a later sexual assault during a massage foreseeable. The two have nothing to do with each other.
Thank you both. 2 Girls versus Laria.
Good afternoon, Your Honors. Edwin Chosey for the plaintiff's appellants. May it please the court. Your Honors, I would like to focus in the time that I have on 2 aspects of these dismissals of various claims that we've asserted in our complaint with respect to the motion to dismiss by the defendants. One is that the court below committed error in connection with determining that the company, as we've defined it, cannot recover damages against the Lareyas for their breach of fiduciary duty, and the company can only do so against Magees under the term sheet operating agreements, paragraph 12. We would submit, Your Honors, that looking at the plain language of paragraph 12, that paragraph does not limit the company's remedies for the Lareyas' breach of fiduciary duty. It does not state that the Lareyas shall not be liable for their breach of fiduciary duty to the company, and that only Magees shall be so liable. It does not use words like only or solely or exclusively. Thus, paragraph 12, in providing for the liability of the entity which with any of the individuals, the subject individuals here are affiliated, adds a remedy by exposing, in this case, Magees, to liability for the Lareyas' breach of fiduciary duty. It does not subtract a remedy against the Lareyas. As the court is aware, it cannot rewrite paragraph 12 by inserting words such as only, solely, etc. that the defendants would have the court do. Otherwise, Your Honors, the company would be providing a license to be defrauded to the Lareyas. And by the same token, Magee's, if they were the plaintiff here, would be providing such a license to the Boschis, which would insulate from personal liability the individuals. And there's no evidence of any such intent in the term sheet operating agreement. The second point, Your Honor, that I'd like to refer to is the employment agreement claims, the breach of contract claims by Holding Corp and by the company against the Lareyas. We rely upon principles of oral agreement, the party's objective conduct, and implied contract. And we've set forth in our brief at page 45 the case law that relates to these principles.
And do you also rely on defendant's counterclaim?
Yes, Your Honor, we do. In the counterclaim, the Lareyas seek their unpaid salary by way of a breach of contract claim under the term sheet operating agreement against both the company and Holding Corp, which is an important point here.
So even if you could get around the issue which the court held that there was not enough specificity in the employment agreement, wasn't the other part of the court's holding that neither of these entities have any standing to pursue these claims because there's no damage to them as opposed to the company? And how do you get around that issue?
We get around that in several ways, Your Honor. With respect to Holding Corp and Quebec, which are two plaintiffs, themselves were harmed by the company's failure to repay the loans.
Okay, so as to the repayment of the loans, those were loans that they were going to be repaid by the company. So if they have any potential claim having to do with those loans, don't they have to go against the company to recover those loans as opposed to third parties who don't have any obligation to repay the loans?
Our claim here, Your Honor, is that the Lareyas themselves are the ones who caused the company to be unable to repay those loans.
But then wouldn't they have to have a direct claim on their own that would support standing to assert those claims?
Well, we've also
damage to themselves.
Well, in addition, Your Honor, to the repayment of the loan, and we believe that they do have standing by virtue of the fact that, again, the claim is that the Lareyas, through their malfeasance and fraudulent conduct, caused the company to be unable to repay those loans. But we've also asserted claims for compensation that was paid to the Lareyas during their period of breach of fiduciary duty and disloyalty, as well as any secret profits that the Lareyas obtained, again, during that time frame. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Benjamin Rubenstein for the respondents, defendants. A few points in response to appellant's points. First of all, just
Can I
by
ask
way...
you a question about
Yes.
paragraph 12? It would be helpful to me if you could explain what part of paragraph 12 you believe precludes the plaintiffs from recovering damages for breach of fiduciary duty from the Lareyas as opposed to only Magee's? And why isn't it read more correctly as expanding the range of liability to include Magee's as opposed to depriving, as opposed to eliminating liability for the Lareyas?
Well, because I think the use of the word will, so it says a breach of fiduciary duty by the Lareyas, by Christy or Kathy, that cannot be cured will result in the entity with which
But it doesn't say that it won't result in a claim against the Lareyas. So why does that exclude it?
Because
I mean, it would be easy enough to have written it the way you want, but nobody wrote it that way, to say will exclusively be against Magee's and not against anyone else. But it's not written that way. So why should we read into that an exclusivity provision which isn't there?
Well, I agree that it's written the way it's written. I think it's also not written in such a way where it says will result in addition to liability against the Lareyas individually, right? It doesn't explicitly preserve the remedy against
But
the
it doesn't
individual.
exclude liability against them either, right?
Well, I think the word will is a mandatory word there, Your Honor, and I do think it
It doesn't say solely, though. This just says it will be a remedy, right?
you're right, it does not say solely. It does say will, and I think that language and I think this provision limits the recourse. And there's a reason it's there, and one of my concerns
Right,
that
the reason it's, isn't the reason it's there to increase the range of liability so that Majis is liable as well?
well, Your Honor, I would suggest that it's a channeling provision instead, and that will provision mandates that the liability that I suppose theoretically, had it not been governed by the TSOA, would then be channeled towards Majis. But I also think an important point here, Your Honor, is to take the important point, and perhaps one of the takeaways here, is that this entire dispute is a contract dispute. It is not a tort dispute. And I think plaintiffs' appellants here have tried to shoehorn additional tort claims onto their contract claims. But this contract, and the language that regardless of where this court comes on the interpretation of it, it clearly shows that the parties contemplated that the fiduciary duty, that any of these tort claims, any of the claims that are being made now by plaintiffs' appellants, that they're breach of contract claims, and they have to be dealt with through the provisions in the contract. And I think that's an important overall point here in terms of dealing with the numerous tort claims that the plaintiffs' appellants purport to appeal. I also just wanted to make one additional point about the employment agreements, which is when you look at the language in the complaint alleging the pre-term sheet operating agreement employment agreements, right? They're unwritten agreements. There's no language in the complaint that tells me what obligations that my clients had and how my clients breached those obligations through their conduct. There's reference then to the TSOA, which again is clear on its face that it contemplates an additional separate employment agreement. But there's no separate allegation of an obligation in a pre-TSOA employment agreement.
If you think that the TSOA is irrelevant to their employment, how do you explain the fact that your clients filed a counterclaim seeking back salary and relying on the TSOA?
Well, as an initial matter, appellant did not include that in the record.
Right, but we can take judicial
Of
notice
course.
of a pleading.
Of course. And this is an example of the counterclaimants doing something that plaintiff failed to do, which is the counterclaimants allege exactly what the agreement was. The agreement was to pay them a salary. And what was the breach? They didn't get paid that salary. That's exactly what happened. That's why they have a claim. There's no allegation of any agreement beyond anything which is just, you're going to work for us, we're going to pay you a salary. I think that's a critical distinction here, if I could respectfully submit that.
Thank you.
Thank you.
I'll be very brief, Your Honor. Actually, just 2 points. The first is that certainly with respect to the black letter law, the plaintiffs are allowed to plead in the alternative and even inconsistent claims. And the second point with respect to the employment agreements, Your Honor, is that we have a 1.5-year period in which the Lareyas performed their jobs as their respective directors of operations and design. They were paid $150,000 and $180,000 salaries during that 1.5-year period. And then we have the term sheet operating agreement in 2017, September of 2017, which adds specificity in terms of provisions such as increases in salary, termination of employment mechanisms, potential payment of bonuses, et cetera. So we would submit respectfully, Your Honors, that the allegations show, by way of the principles of oral agreement, the parties' objective conduct, and implied contract, that both before the term sheet operating agreement and after the Lareyas were subject to employment agreements. Thank you.
Thank you. Thank you both. Aoki versus Aoki.
Good afternoon, Your Honors. May it please the Court. James McGuire for the appellant. I think, as Your Honors know, well, one of the reasons why we're here, what initiated it, is that there was a proceeding that Devin and Stephen contended was a pure construction proceeding.
Well, let's understand certain things that you will not disagree with.
Sure. I hope I won't.
You agree that the EPTL has a safe harbor provision that would allow someone to challenge a no contest clause?
Absolutely. It's a part of a comprehensive statutory scheme.
Fair enough.
Numerous exceptions, numerous safe harbors.
Fair enough. And you will also agree that another provision of the EPTL, 11-1.7, allows that would suggest that any attempt to give total immunity to someone like your client would be against public policy. You agree with that?
Well,
isn't that the language in the statute?
Well, no, it prevents exoneration of a fiduciary for certain kinds of acts, from failure to exercise reasonable care, diligence, and prudence.
I understand.
But that's not the same as
fair
complete
enough.
immunity. There is immunity that is permitted by law. And the ultimate problem, which we'll get to later, I hope, but I'll follow Your Honor's lead, the ultimate problem here is that they tried to take away, in the construction proceeding, they threw out the baby with the bathwater. They wanted to throw out and invalidate the provisions that are prohibited by that precise section. That's 1A. And they wanted to throw out the ones that were permitted. And they said, by public policy. And judge and the surrogate disagreed, and properly so. And eventually we'll come to see that's one of the reasons why the safe harbor that the surrogate did not rule on, but they contend does not apply. But the first safe harbor, the only one that the surrogate addressed, was a different one, Your Honor. It's the one under 3-3.5, was it B3E? And I hope you'll excuse me, that's a mouthful, so I'm just going to say E, right? Because I'll get it wrong if I try to do anything other than just say, call it E. And that provides a safe harbor for a construction proceeding. So now we have to find out, what is a construction proceeding? They said that the proceeding that they brought back then was a construction proceeding. And here's the point. Here's
So weren't they trying to determine the scope of the BAIC?
Well, that's the ultimate issue. But I'm trying to get there, Your Honor, but I think it's really important that you understand that there's two safe harbors at issue.
So
and
you're not...
And I'm trying to address the one that the surrogate ruled on. And then I think that's the only orderly way to do this, but again, I'll try to follow your lead, is to then address the issue that Your Honor just raised. So if you'll I hope you'll indulge me. I think that's really going to help the court if we proceed as the surrogate court did. Surrogate court didn't have to reach that issue, the one you're raising, because of the other safe harbor that it found.
Okay.
Okay. So on that safe harbor, it's a safe harbor when you do bring a construction proceeding, and it makes eminent sense. These interim clauses have a lot of teeth, and they can have really serious consequences. So what the legislature is saying here is, look, if there's ambiguity in a will, and you're subject to a potential interim clause, you shouldn't have to act at your peril. You should be able to find out what it means. You should ask be able to construe it. Find out what is intended by the testator, what he meant. And you can take a point of view. You can say, I think this is what it means. And it doesn't matter if what it means would then arm you with an argument that's valid, because then you would have, the safe harbor would have done its purpose. It would have shielded you. It would have prevented you from acting at your peril. So it's an eminently sensible provision. But it's limited to construction proceedings. So what's a construction proceeding? And the point here, Judge, is that the surrogate ruled that it was a construction proceeding because it was brought under Surrogate Court Procedure Act, Section 1420. And that has a title. The title of Surrogate Court 1420 is, quote, proceeding for construction of will, effect, or decree. And in that, it permits challenges to validity and also proceedings to determine the effect. But that doesn't mean that there's no distinction between a challenge, a contesting of the validity of a provision, and construing it. Of course there is. The title is not part of the text. We all know that. And so simply because the proceeding was brought under a section denominated proceedings for construction of will, well, that applies. So if it had a challenge and in it, it doesn't matter under the surrogate's ruling. And that's got to be wrong. And for the reasons that I've said, including the reasons that I've said.
But I think the critical question is the proceeding that they brought a construction proceeding, whether because of the title or because of the substance of their claim?
Well, it's not a construction proceeding because there is a challenge, and that's, again, I understand it's an important issue that we've got to get to, but my point is that it didn't matter for the surrogate whether or not it was a challenge to validity. And my point is that if it does have a challenge to validity, which I'm aching to get to, because it does, but if it does have a challenge to the validity of a provision of the will, the safe harbor does not apply, because that would mean that the whole comprehensive legislative scheme could be demolished. All you have to do is form triumphs over substance. All you have to do is say, okay, I want to construe provision A, B, and C, and by the way, I'm challenging C, right? So that can't
you address whether or not the proceeding brought by petitioner, I'm sorry,
the construction
against the petitioners was in fact a construction proceeding?
Okay, now I'm going to turn to that issue. I just wanted to.
That would be good.
But I'm sorry if I frustrated Your Honor. But it's just that I wanted to address the actual ruling by the court. And what I've just said, if you accept it, that has to be wrong. That simply because it's denominated 1420 proceeding, that the safe harbor applies. If you accept that's wrong. The surrogate is wrong for that. So then we have to reach this issue. So now I'm going there. Now, they contend that a contest under subsection C of the statute that we're now talking about, a contest to the validity of any grant of a power or immunity prohibited by A1, right? To use a statute's phrase, any such quote within the purview of this section, end quote, is safe harbored. So if you do challenge only the powers, only the privileges and immunities, powers and immunities that are prohibited by it, if you only challenge it, you got the safe harbor in there. So then the question is, did they go beyond that? And the fatal problem for them is that they did do that. They sought to invalidate a provision of the BIC solely they didn't seek to invalidate it solely on the basis of the ground that it violated the terms of A1. The declaration they sought asked to deprive Kiko of all the powers and immunities from liabilities. Back to the question before. That broad conferral of powers and immunities was obviously designed to protect her to the maximum extent it could. It couldn't go as far as it did. But that doesn't mean that the whole thing has to be invalidated. In fact, their action was in the teeth of another provision of the subdivision that says, to the extent that to the extent that it is invalid, the rest remains. And they didn't care about that. They said the rest goes. So we said, look, it does violate, parts of it does violate these prohibitions of A1. And when the sensible suggestion that was made was, this was Kiko. Put a limiting construction on it. Read it so that To the extent it exceeds those powers, it's not valid, but the rest of it remains. On reply, they had nothing to do with that. Nothing. They doubled down. They conceded nothing. They said, the quote, and this is at A177, the BAIC, which states that the trustee, quote, shall not be held accountable or surchargeable as a fiduciary under the will for any action taken, end quote, as an officer or director of BOT is unenforceable as a violative of EPTL 11-1.7 and public policy more generally. They said, no thanks, don't want that limiting construction that would save the legitimate power, immunities that she gets. Nope, they didn't want that. So they clearly brought a broad challenge, and it was really a facial challenge. And they did seek construction of other provisions of the will. We don't dispute that. But this was a challenge to the validity, and that means the interim clause kicked in. And finally on this point is, the surrogate got it right and disagreed with them. The court recognized that under 11-17A, it couldn't exculpate her for failing to exercise prudence, diligence, and reasonable care. But the court also recognized that it could exculpate her for other duties, just what we've been talking about. It's obvious that it could. It specifically identified the duty of undivided loyalty. And the surrogate held that the duty may be relaxed, which is what this BAIC did, although not to the extent of eliminating a fiduciary's obligation to avoid improper self-dealing or actions taken in bad faith. And the court squarely rejected this facial challenge. It concluded that a determination of the extent to which the BAIC exculpates Kiko would have to be made in actual proceedings, seeking to hold her liable. Had to be done on a case-by-case basis. Let's look at the facts. Is this something that is can permissibly exonerate? She already identified it does allow for permissible exonerations. So for those reasons, and I see I'm out of time, I haven't a chance to address their other issues, but maybe I'll have some time on reply. But for now, I'll just say that what that means is, if you accept that argument, one, that it does matter whether or not there's a challenge, and that 1420, the title doesn't alone bring you within the safe harbor. And if you accept that they challenged the good as well as the bad, that they were trying to throw out the baby with the bathwater, that means both safe harbors, the only two they rely on, do not apply. The interim clause is violated. They have no interest. They can't pursue these accounting and removal proceedings. They got no standing to do it. And it means that the guardians, wards, don't either. And that's because if they violated, Devin and Stephen violated, then their children are deemed to not have survived Rocky. They couldn't have inherited anything. Thank you.
You got it. Good afternoon, Your Honors. May it please the court. David Rose, prior cashman on behalf of respondents Devin Aoki and Stephen Aoki. I'll start with an argument that I made below, and it's namely that there is a...
Could you start with whether or not the proceeding that your clients brought was a construction proceeding or something else?
Yes, I will start with that. And that's exactly where I was going to start. And there's a perverse irony to this appeal and the motion that was made below, because the will construction proceeding was brought for the very purpose, and expressly stated it was brought for the very purpose of avoiding an alleged violation of the no contest clause, and the very circumstance that we find ourselves in here. And when the will construction proceeding was commenced, Devin and Stephen, my clients, relied upon statutory safe harbors and a century of well-established, settled decisional law that beneficiaries can bring a will construction proceeding asking a court to make a determination as to the validity or invalidity of a particular will provision, that they could advocate for a particular position when doing so, and they could do all of that without fear that they will be held to have violated a no contest clause when doing so, even though, and this is a quote from a case called Matter of Robbins, in reality, the proceeding may represent an indirect attack on a will. And so the surrogate, in her order below, correctly, cogently, and very convincingly held that Devin and Stephen had sought a construction. She was the very same jurist who had determined, decided the will construction proceeding. She knew what it was, and she called it as such in the order on appeal. And that they had brought that proceeding within the statutory safe harbor of EPTL 3-3.5B3E. And she cited law going back in her decision 89 years for the proposition that even if what had been sought in that proceeding could be characterized as a challenge to the validity of the will provision at issue, it was still a construction proceeding covered by the safe harbor for proceedings or construction of a will.
So stated a little differently, they're seeking the scope and breadth of the BAIC right up front, but at the same time in that context, seeking the removal of the trustee because of breaches of duty and an accounting, et cetera, is not violative and would not vitiate the safe harbor.
That's correct. What was intended was a proceeding that would, at the end, with its decree, determine whether our clients could bring a removal proceeding and other proceedings to hold the trustee accountable without risking a violation of the interim
So it was
clause.
kind of a DJ action initially to determine the scope.
It was, and that's permitted by, again, the century of case law, and I could rattle off cases to the panel that have held that for over a century, pre-enactment of the state safe harbor and consistently post-enactment of the safe harbor. And what's interesting about the post-enactment cases is that, ostensibly aware of those, the legislature has taken no action whatsoever to alter, amend, or otherwise change the safe harbor, EPTL 3-3.5B3E, despite that case law, and despite having gone back and amended other provisions of 3-3.5. And so that's an indication that the legislature has determined that its intent with regard to that safe harbor has been faithfully observed by the courts addressing it. And I talked about that safe harbor going back over a century. It was codified in the safe harbor. That case law has been carried forward. And that is all why Keiko cannot cite one single decision supporting the position she takes here and the radical reformation of the settled law that she asked this court to undertake. She can't cite one case contrary to the surrogate's conclusion that the relief that Devin and Stephen sought was protected by the safe harbor. And I believe, Justice Shulman, you asked a question earlier about what is a proceeding for the construction of a will. If you look at the safe harbor, 3-3.5B3E, it talks about a proceeding for construction of a will. It doesn't talk about a construction of a will. It talks about a proceeding for the construction of a will. What is a proceeding for the construction of a will? What is the procedural mechanism by which it's brought? What is the authority pursuant to which it is brought by a party? It is the simultaneously adopted, with the safe harbor, SCPA section 1420, titled, as we heard, Proceeding for Construction of a Will. And so you have a safe harbor that is adopted simultaneously with a procedural mechanism bearing the very same title, and all courts have viewed that as the way these cases are to be interpreted. If you look at what a proceeding for construction of the will is, if you look to 1420 specifically, the statute makes clear that a party in interest can seek a determination as to the validity, the construction, or the effect of a will provision, and makes clear that when doing so, the petitioner must, among other things, identify the necessity for the construction. So by using validity, construction, and effect up front, and then requiring that the construction sought be articulated, the legislature made very clear that in each instance, validity, construction, or effect, the petitioner is seeking a construction. That construct, where you have validity, construction, and effect used, and then followed by the singular use of construction afterwards, follows in each of subsections 1, 2, and 3 of 1420. I see I have a minute left. I'd just like to address briefly this notion of the safe harbor in 11-1.7 of the EPTL. Appellant gets it wrong in the sense that she posits that that safe harbor is addressed by the nature of the proceeding brought. Actually, the safe harbor applies with regard to the nature of the provision challenged. The safe harbor in 11-1.7c says that there is a safe harbor with respect to a contest to a provision within the purview of that statute, meaning one that seeks to absolutely absolve a fiduciary from being questioned in any respect. This notion that we doubled down, I only want to address it very briefly. We didn't double down. We identified for the surrogate in our reply brief what the other side's position was in her opposition. That's all. We pointed it out. There was nothing to accept, reject. We were just noting what the other side had said. That's apparent from the brief itself. Unless the court has any questions, I will rest there and on our papers. Thank you.
Good afternoon, Your Honors. Jessica Biquette, the guardian ad litem in this case. I just want to highlight for the court one point that I think is very important, and that is that if there was a facial problem with what Devin and Stephen did in bringing this construction proceeding, it was known to Keiko in 2018 when the proceeding was filed. She had the ability in an answer to counterclaim for another construction that the interorum clause had been triggered. At the time, she was the trustee. She is now suspended as trustee, so she clearly had standing at that time. She didn't do that. And the reason she didn't do that is because this argument is nothing more than an afterthought. This is something that was concocted in 2022 when we were approaching the deadline for the completion of discovery, when she had not complied with her discovery obligations, when I had filed my JL report, which she didn't respond to, where I highlighted how for years she obstructed discovery. Not only to Devin and Stephen, but to me, the court-appointed guardian ad litem. And the result of that obstruction is a charge to the trust, to the extent that my fees are apportioned to the trust. Before she was suspended, she was paying her own fees to the trust.
Did she ever give any explanation for why she waited 4 years to bring that?
No, not that I'm aware of. And there is no reason, other than she did not want to face the day of reckoning for her conduct. So as the court in Maddle of Kittelberger, a case that I cited in my brief, said, when someone waits this long and their purpose is clearly only to unseat their adversary so that they don't have to face the day of reckoning, they cannot raise standing as an argument, as Keiko seeks to do now. This is a strategic litigation maneuver that she's engaging in. Regarding my wards, interorum clauses there is no public policy in the state of New York, as Keiko claims, that is pro-enforcement of interorum clauses. They're actually disfavored, they're construed narrowly, and equity abhors a forfeiture. And this clause, as written, states only that if a contest is mounted, the contesting beneficiary's interest is revoked. And the only people who are claimed to be contesting beneficiaries are Devin and Stephen. I don't agree that they are, but even if they were, that wouldn't result in the forfeiture of my ward's interests. To the extent there is any ambiguity in the language as to whether Devin and Stephen have predeceased for all purposes if they triggered the interorum clause, or only with respect to their own interest, that has to be construed in favor of my wards, narrowly, and that they wouldn't forfeit their interests. And the reason that Keiko does not claim that my wards or I are contesting beneficiaries is because the EPTL explicitly provides that infants can never trigger an interorum clause because it is against the public policy of the state of New York, the reason being that a guardian ad litem such as myself and the court, such as Surrogate Maya, have a duty to protect infants at all costs, and a testator is not free to interfere with that duty in an interorum clause that is put into a testamentary instrument. And as a final point, the context for this appeal is that there were dueling summary judgment motions below. One of those motions was a motion that I made for Keiko's summary removal as executor and as trustee. In light of this motion that she made, a proceeding that she brought to declare the interorum clause triggered, juxtaposed against the history of this matter and the obstruction in this matter. And I submit to you that the surrogate abused her discretion in denying my motion, which this court can reach by searching the record on these dueling summary judgment motions, because what the surrogate did not say in her decision is that where hostility is so intractable that it interferes with the administration of the estate, that is a basis for removal. So regardless of who engaged in litigation tactics or maneuvers, there is no question that this decedent died in 2008. And we are standing before you in 2023 on what I believe is at least the third appeal to this court. This case has been to the Court of Appeals. There are innumerable motions that have been made to the surrogate, and this case has been delayed extensively and repeatedly for no reason other than hostility that Keiko herself admitted in her first proceeding, because yes, this is the second time she is asking a court to declare that Devin and Stephen triggered the interorum clause. In the first proceeding, she said it would be an understatement to describe her feelings toward the children of the decedent as hostile. And hostility is a basis for summary removal of a fiduciary. And in fact, very recently, there are two Second Department cases from 2021 and 2022 where the Second Department reversed the decision of a surrogate not to remove someone where a fiduciary, where hostility had resulted in the estate being open 13 years later, 15 years later, and that is precisely what you have here. And to the extent the surrogate concluded there was no need for summary removal because there is no potential for harm to the trust assets because the fiduciary, Keiko, has been suspended, that is not correct, because the harm is in the delay that continues, the machinations that Keiko engages in, even claiming she's doing so as executor, which even if she is suspended and can't pay her own fees from the trust, I will have to make a fee application at some point. And the presumption and what normally happens is that those fees are paid from the trust itself. So to the extent that I continue, I was appointed in 2018. It's now 2023. For 5 years, I have been working on this matter. Every time I have to do something and respond to one of these maneuvers that she makes, the trust is diminished, regardless of who the ultimate beneficiary is. And to the extent it is Devin and Stephen, and in Stephen's case, he has reached age 45, so his interest is vested now, every dollar he spends from his own pocket fighting this is a net loss to him, because to the extent he gets something back from the trust, he had to spend $1, $2, $3, $4 million to get to that point. And surely that is not what the decedent intended here. Thank you.
Well, I have 2 minutes to reply, and I was unfortunate because they threw up this grab bag of things, and I hope your court will give me some extra time here because I can't deal with that.
It was everything that was in the briefs, I believe. There wasn't
pretty much, but there's misrepresentation to the misstatements being made here. First of all, no explanation for the delay. That's their burden. They have to show that there was an unreasonable and excusable delay. They have to show it as a matter of law.
What was the reason for the 4-year delay?
It's not. There's nothing on the record on it, but that doesn't matter. It's their burden to show it, and they didn't show it. There's been no finding here, Your Honor.
There was no explanation.
But there's been no finding that she did it for an improper purpose. None. That's a form of prejudice. If it was found, it was not found, and they haven't met their burden on that. So that goes away. It just completely goes away because they didn't meet their burden. Now, there's another thing about the wards. Nobody's saying that they triggered it. No, the minors can't trigger it. Nobody's saying they did. What we're saying is that Devin and Stephen did, and under the will, that means they predeceased. They didn't take any actions. That's the consequence of what Devin and Stephen did. So, I'm not even going to respond to the notion on search the record, which you can't do anyway because it was another motion. Let me go to some of my adversaries' arguments. The irony here is, that's what they try to do. They put in their papers, we're trying to seek this protection. But then they went too far. That's the irony. They clearly went too far. They sought to invalidate that provision. They can say all they wanted. Here's what our purpose was, but they went too far. They did double down. We explained it in our brief. Now, they talk about all this precedent that supports them. I didn't even bring those cases here. I read them all. I stand by our distinctions, what we made in our brief. I just stand behind them all. They're cherry picking about cases that are either irrelevant or they might be able, one or two might eke some support, but it doesn't matter. What matters is the plain language of the statute. There are all these old surrogate court cases, right? And none of them, they're all, look at them all, they're all ambiguous. There's no appellate court on point, and it's controlled by the plain language of the statute, not by what some surrogate court said. There's been no appellate court that's reached this issue. And they can't, and that's what they can't cite one appellate court that supports them on this. So that's just pure cherry picking. Now there's an argument here that this crazy interpretation of Section 1420, no matter what you do, you stick a validity challenge in it, it's fine, that's okay, my adversary says, because of the last sentence of 1420 subdivision 1. Which requires the petitioner request a determination of the court and the necessity for construction. So if you have to show the necessity for construction, he says, well, that must mean that means you have to show shows that the legislature is treating determinations, requests for validity, and challenges to validity and requests for determinations of effect as all the same. That makes no sense. That language in here, the necessity for construction, is there because it's unique to a construction proceeding. Why? Because if you bring a construction proceeding, there's no reason for it unless there's ambiguity. Right? So you have to show that there's ambiguity that needs construction. And of course you can take a point of view. We've never disputed that. That's the whole purpose of it, is to allow to take a point of view. But you can't cross the line. They crossed the line, and the motion for summary judgment should have been granted because they have no interest. The only interest they have is as those beneficiaries. When that goes away, they can't prosecute the accounting and removal proceedings, and nor can the wards, because as a matter of law, they predeceased Rocky, and if they were dead when he died, they can't have any interest. It's as simple as that. Thank you, Your Honor.
Thank you all. McInerney versus the Archdiocese of New York.
Good afternoon. May it please the court, Patrick Lawless for the defendant, Archdiocese of New York. The Supreme Court abused its discretion in directing the Archdiocese to produce documents with respect to subsequent bad acts and subsequent corrective measures. These documents are not, first of all, they're not relevant to the plaintiff's negligence claims and negligent hiring, supervision, and retention claims. The only documents or discovery that would be relevant to those claims would be any document showing that the Archdiocese had prior knowledge of the subject priest.
Why does the discovery have to be that narrow? Why isn't the discovery broader than that? We're not talking about what would be admissible at trial. We're talking about what will help them to best investigate whether what acts occurred.
Well, first of all, you have the overwhelming case law that says this isn't discoverable. Then you also have Judge Silver's order dated March 30th, 2021, which says that subsequent corrective measures is not discoverable in CVA cases.
We're not talking about subsequent corrective measures. We're not talking about corrective measures. That's not what they're trying to find out, what was corrected. They want to know what happened and whether there were other instances of it. That's what they're looking for.
It's still not relevant to their claims. The only documents that are relevant is what would happen prior to the knowledge that was prior to the latest date of alleged abuse. And in this case, that was 1976.
Unless there's something,
Right.
Unless there's something that is in documents afterwards that pertains to what happened earlier.
But there's no evidence in this case, and there's no document in this case that indicates that the Archdiocese had any prior knowledge, even subsequent documents. The plaintiff relies on the grand jury report in Pennsylvania, but that only references a complaint that was made in 1985, which is 9 years after the date of the latest abuse alleged in this case. So it's not relevant to showing that the Archdiocese would have had any prior knowledge to 1976. That's not relevant. Actually, if anything...
Why isn't it relevant? You're saying merely because of the date? It's not
No,
relevant?
no, it's the nature of the claim. The nature of the claim is negligence and negligent hiring, supervision, and retention. And the case law is clear that the only relevant inquiry for those claims is prior knowledge of a propensity to commit the abuse. It's not subsequent acts and subsequent
But it's
corrective
not,
measures.
you mentioned that before, and I said, but this is not about the subsequent acts. It's about what might have come up in that would shed light on the offenses that we're talking about here.
But that is purely speculative, and speculation
speculative?
isn't sufficient to justify discovery.
But it's only speculative because they can't get discovery about it. Part of what they're seeking, for example, is treatment records of Mr. Paracow. And it might well be that in the treatment records, he might have acknowledged prior abuse or prior conversations with the Archdiocese, which would be extremely relevant to the plaintiff's claim here. So I'm having trouble understanding why discovery should be so narrowed. We're not talking about admissibility, we're just talking about discovery.
But again, there is case law after case law saying that this is not discoverable. It's not relevant to the claim, and there's nothing.
Why isn't?
It's just purely.
Let's look at the example I gave you. Why aren't his later therapy records relevant? Because they may include disclosures about what happened before.
They're not relevant because it's pure speculation to say that they may reveal this information. Again,
If they don't, then there will be nothing at issue. But the question,
But
it's also the only way that could be found out, right?
But then you're asking the Archdiocese to turn over documents which are not relevant, which the case law is
But they
clear
may
is
be
not
relevant.
relevant, and then you're asking them to turn over documents, and it's not just in this case, it's in all other cases, and then it's going to lead to endless discovery with respect to, again...
We would only be deciding it in this case. Judge Silver's, Judge Silver?
It's part of the CMO
Judge
that
Silver's
documents
CMO
can be shared in other
wasn't
CBA cases.
exclusive. It was a basic definition of what was admissible, but it didn't exclude more evidence in a particular case, more discovery in a particular case.
And it's only with regard to this particular priest, the accusations against this particular priest.
And there is no evidence that there's any prior knowledge, and it's just pure
Well, if there's no evidence, then that's what will be found. You're saying that it's going to be so broad. This is one case that we're talking about here.
I understand that.
And
but
there has to be a link to the particular case. It can't just be that somebody comes up with, 10 other cases that have no link.
But it's just clear, and it's black letter law, that when it's the plaintiff's burden or the party who's seeking discovery, it's their burden when they're seeking discovery to show that it's going to turn over relevant evidence, and an unsubstantiated speculative claim that it may lead to relevant evidence is insufficient. And that's all we have in this case. It's just pure speculation.
Thank you.
Thank you.
Good afternoon, Your Honors.
Let's start there. What do you have other than speculation?
Yes, well, ironically, I mean, as Your Honor correctly points out, often discovery is speculation and hypotheticals because we don't have the documents, right? They've been withheld from us. That said, this case is actually unique in that it is not speculative. We have the Pennsylvania grand jury report, which the only reason we know that these documents were withheld from us was because of that Pennsylvania grand jury report. Otherwise, the Archdiocese didn't even provide us with a privilege log. We had no idea that these documents had been withheld from us. And what that Pennsylvania grand jury report shows is that the documents that have been withheld are likely relevant on the issue of notice, namely, and we have many examples in our briefing, but namely, that there was a survivor who came forward in 1985 and informed the Archdiocese that he had been abused in 1970. That predates our client's abuse. I would like to know what that report looks like and what that witness has to say about his abuse that predates our client's
At this particular parish.
at this particular parish by
With-
this
by
particular
priest.
Correct. And likewise, it's also discoverable on issues completely unrelated to notice. Namely, in order to rebut the Archdiocese's affirmative defenses and their denials. It's certainly not speculative because we know that Father Paracow's treatment records will reflect that he admitted to abusing 35 children while he was a priest within the Archdiocese of New York. Now that is highly relevant to corroborating my client's claim that he was sexually abused, which the Archdiocese disputes. In their answer, they say he was not sexually abused by Father Paracow. We need this evidence to rebut that. It's likewise relevant to a question of employment, to agency, to control, all of which are disputed by the Archdiocese. It's relevant to how he used his position to access children. That is disputed by the Archdiocese. It's relevant on the question of lack of mistake, motive, pattern and practice, all of these things which are denied. And as this court knows, this is a discovery motion, right? So at the end of the day, if it is relevant on any of these, if it is material necessary on any of these, it should be produced.
Would you agree that of those 35 victims, if they post-date your client's period of abuse, that could be an issue in terms of admissibility?
Could be an issue as far as admissibility, yes, Your Honor, I do agree. But again, we're here on a discovery motion, right? The question of admissibility will come. We would like to see what these incredibly important records show about Father Paracow and whether they are admissible on the question of notice or admissible on other questions, as I pointed out. I think it's notable that if the Archdiocese was correct on this artificial line that they're attempting to draw, the documents that post-date the abuse, plaintiff himself would be precluded from receiving a report that the Archdiocese made on his abuse, if that exists, simply because it happens to post-date his abuse. Now, of course, that's an absurdity, and that's not what the case law shows. Very briefly, lastly, we ask that this court enter an order, obviously affirming the trial court, remanding it back for production of the documents, but also making clear that the Archdiocese can't raise new issues on remand. Why these documents are supposedly withheld has been a moving target from the moment we did a meet and confer with the Archdiocese up and through this appeal. And this case has been litigated for 3.5 years. As much as I enjoy being here, I'd like to not be here in another year disputing as to why these documents have still not been withheld. They've had an opportunity to raise all the issues.
Not been provided, you mean?
Anything not raised has been waived. Thank you, I appreciate it.
Thank you.
Plaintiff's arguments just demonstrate how speculative these claims are. And the Pennsylvania grand jury report only reflects a complaint that was made in 1985, and it has to do with statements that were made after that complaint in 1985, and it has nothing to do with the allegations in this case.
And I think the easiest thing to do, sounds like, is to produce it all, and so that it can be reviewed, and anything that's irrelevant will be ignored. Certainly, there's a judge who is going to be a gatekeeper at trial who is not going to permit certain documents from coming in, but to the extent that these documents allow for investigation and to determine whether or not this particular priest was involved in any activities on or before the time that this particular complainant is alleging, it sounds like it's relatable.
But I would say, if anything, the grand jury report shows that there were no complaints prior to 1985.
Except it specifically talked about one individual who claimed that his abuse began in 1970.
That was done in an interview that happened in 1985. That post-date by a decade, the alleged abuse in this case.
But the alleged abuse in that was revealed in that interview occurred in 1970 prior to your client, prior to their clients, prior to to the
But-
range of their client's abuse.
Again, there is nothing in that grand jury report, and there's nothing in the documents that we've already turned over. We have already turned over relevant portions of Father Perico's personnel file, and there's nothing in these documents that suggest any notice prior to 1976, and just speculation that they may reveal something prior to 1976 does not warrant their production.
Thank you.
Thank you.
Thank you both.
You too, thanks.